now in session. The Honorable Michael J. Kelly, the Honorable Marion Bozzi, and presiding the Honorable Ellie Green Maldonado. All persons having business herein draw near, give attention, and they shall be heard.
Good morning. On behalf of myself, Judge Kelly, Judge Bozzi, and Judge Treblecock, who will be joining us shortly, welcome to our case call. We see some familiar names on our call today, and we understand that these cases are important to the litigants and counsel, and we assure you they are important to us as well. We have been diligently working on these matters, and we've had the benefit of your excellent briefing as well as the work of our research division and our chambers. We are familiar with the relevant facts and pertinent law, and we ask you to focus on your salient points. We are hearing matters involving sexual assault victims, personal protection orders, and children. Because these proceedings are recorded, we ask you to please substitute initials in lieu of using a victim's, petitioner's, respondent's, or minors' full names in these cases. So due to a conflict in our first case, Judge Bozzi has agreed to substitute in. After we hear that case, we will take a short break and Judge Treblecock will join us. With that, we look forward to hearing your arguments, and I will help you keep your time. Yes, I will. I will help you keep your time, but I also ask that you keep your own time. So we'll call our first case. We're going a little bit out of order today. It's number 25, and that's 373-443, Elby versus Detroit Land Bank Authority. Yeah, I see. I'm sorry, counsel, we can't hear you. Are you on mute?
Can you hear me now?
Yes, we can. Great.
All right. Good morning. I want to draw the court's attention to a Sixth Circuit case that was published after the briefing was completed in this matter.
Can
and
you
that's
start by placing your name on the record, counsel?
Ian Cross, P83367, appearing on behalf of the plaintiff appellant Elijah Elby.
Okay. You may proceed.
So I want to draw the court's attention to a Sixth Circuit case that was published after the briefing was completed in this matter, and that is Mockridge v. Harvey, 149 F. 4th 826, Sixth Circuit, August 11th, 2025, which is directly on point with respect to a lot of the issues in this appeal. The defendant relied on Widgren v. Maple Grove Township, 429 F. 3rd 575, Sixth Circuit 2005, to argue that the search was lawful. And we argued in our briefing that Widgren is no longer good law in light of United States v. Jones. And in Mockridge, the Sixth Circuit recognized that Widgren is not applicable outside of the tax assessment context and probably has been overruled even in the tax context by Jones. Mockridge is also relevant to the argument that the searches of the exterior of the houses are legal if the houses are vacant. In that case, the plaintiff built a group of 200 square foot mini cabins on a large rural property. The mini cabins weren't occupied on a permanent basis. They didn't even have bathrooms. And the defendants were municipal officials who trespassed onto the property looking for violations of municipal zoning and building ordinances. And they inspected the mini cabins from a few feet away while the cabins were vacant. And the Mockridge panel denied qualified immunity to the officials involved in the search. That's important for two reasons in this case. One, the curtilage of the cabins was protected from Fourth Amendment intrusion despite the fact that they were vacant. Vacancy just didn't matter. The panel held, quote, "The Mockridges are entitled to Fourth Amendment protection because their mini cabins are houses," as the amendment uses that term. So basically, as long as the structure is a house, it and its curtilage are entitled to Fourth Amendment protection regardless of occupancy. So the Detroit Land Bank Authority's policy, as alleged in this case, was to send contractors to photograph all four sides of every residential property in the city of Detroit that had been identified as vacant in a postal service database. And to photograph the backsides of the houses, the contractors entered the backyards. So our position is that every time they're going into the backyard of a house, regardless of it, whether it's vacant or not, without a warrant to photograph it, looking for municipal blight ordinance violations, they're violating the Fourth Amendment rights of the homeowner. Second, the curtilage issue. In Mocker Ridge, the municipal officials approached within a few feet of the mini cabins, and that meant that they were within the curtilage, even though the structures were not intended to be permanently occupied, and even though there was no fence or garden or anything special about that land. Mocker Ridge basically says if you're a few feet away from the wall of a residential structure, you're in the curtilage. And that's what the complaint alleges happened in this case. The driveway is about 3 feet away from the side of Mr. Ellaby's house. So our position is that under Mocker Ridge, the driveway is curtilage.
Is
And
Mockridge binding on us?
I'm sorry, what was that?
Mockridge binding on us?
It's not, but it is persuasive.
You seem to be spending an awful lot of time on it.
Well, most of the briefing in this case was based on Sixth Circuit law. So to the extent that the defendants are relying on Sixth Circuit law, I think what they're relying on is no longer good law.
Argue whatever you want.
Now the defendants also argue that the driveway cannot be curtilage because it's on a separate parcel with a separate tax ID number. But Mr. Ellaby owned both parcels. The driveway served the house. And I don't think they've cited any authority for the argument that because you have two parcels and one residential property occupies two parcels, that one parcel cannot also be part of the curtilage of the house that it's right next to. And then the second issue is the MCR 2.116 I-5 issue. Our position is that Liggett Restaurant Group, which both parties have cited, has the same procedural facts as this case. You have a plaintiff who has not filed a proposed amended complaint, but has asked for the opportunity to amend in the event that the court were to grant a C8 motion for summary disposition. And Liggett holds that dismissing under C8 without giving the plaintiff an opportunity to file an amended complaint violates MCR 2.116 I-5. I think we've clearly preserved that issue, both in the briefing and in oral argument before the trial court. Our position was that the defendant's motion for summary disposition under Rule C8 should have been denied, but that if the court was inclined to grant it, we should have been given an opportunity to amend, and we weren't. So unless the court has any questions for me, that's all I had to say.
Nope, thank you very much. You have time for rebuttal.
Thank you, Your Honor.
You're welcome. Counsel?
Good morning, Your Honors. Dave Berg on behalf of Defendant Appellee Detroit Land Bank Authority. In order to state a Section 1983 Fourth Amendment claim against the land bank, Mr. Ellaby had to allege two things. He had to allege that his Fourth Amendment rights were violated, and he had to allege that the Detroit Land Bank caused that violation. I want to address each of those points in turn. The first critical issue is that in order to hold the land bank liable, Mr. Ellaby was required to allege that the land bank violated his Fourth Amendment rights. Here, Mr. Ellaby alleges that the land bank violated his Fourth Amendment rights by trespassing on his property to photograph the rear exterior of his house. And this occurred in the context of a civil enforcement action. The land bank filed a civil nuisance abatement suit against Mr. Ellaby. That suit was subsequently dismissed when the land bank learned that Mr. Ellaby lived at the property because the land bank's policy is not to pursue those actions against occupied properties. In its brief on appeal, the land bank argued that it is not a Fourth Amendment violation when a municipal employee trespasses on private property to photograph the exterior of a residence. And we relied on Widgren v. Maple Grove Township. That's 429 F. 3rd 525. That's a 2005 Sixth Circuit case. And contrary to what Mr. Cross has argued, Widgren is still good law. In Widgren, the Sixth Circuit held that a municipal employee does not violate a citizen's Fourth Amendment rights when they, quoting here, by entering the curtilage for tax purposes of naked eye observations of the house's plainly visible exterior attributes and dimensions, all without touching, entering, or looking into the house. Now, as the Widgren court explained, this makes sense because civil enforcement actions are intrinsically less disruptive and intrusive compared to criminal investigations. And the Supreme Court has consistently recognized that the primary concern of the Fourth Amendment is the right of Americans to be free from government intrusions into their houses. Conversely, visual observation of the exterior of a house does not raise the same level of Fourth Amendment concerns. And that's a Supreme Court case, Kylo v. United States, 533 U.S. 27 at 32. Accordingly, the allegations here that the land bank's contractor walked down the driveway on a separate parcel of property to photograph the rear exterior of Mr. Ellaby's house without touching or looking into any of the windows simply doesn't arise to a Fourth Amendment violation. Now, Mr. Cross has argued that Widgren is no longer good law. I want to dispute that. So first of all of the cases that Mr. Cross relies on to say that Widgren is no longer good law arise in the context of a criminal investigation as opposed to a civil investigation. Those are cases like Florida v. Jardines and Collins v. Virginia. Those both Supreme Court cases, both involved criminal investigations, and in Jones v. United States, which Mr. Cross mentioned as well. Second, the Sixth Circuit has never overruled Widgren. And in fact, in August 2025, in actually the same week that the Mockridge opinion that Mr. Cross referenced came down, the Sixth Circuit reaffirmed that Widgren is still good law. And this was in a case, Hirschfuss v. City of Oak Park, Michigan. That's 150 F. 4th 489. And then it's at page 484, note 3. And the Hirschfuss case involved allegations that a municipal employee had trespassed in the curtilage of an apartment building to photograph its exterior. And that issue didn't directly arise in the case because it involved a facial challenge to a municipal ordinance. But in a footnote, the Sixth Circuit said if the petitioner had raised that issue, he would have lost because, I'm quoting, an administrative official conducting a visual inspection of a house for civil enforcement purposes without touching, entering, or looking into the house does not violate the Fourth Amendment, even if he trespasses. Now, I want to also distinguish this Mockridge case because in that case, there were allegations that the inspector went right up to these cabins, which were found to be houses effectually, and looked into the windows to inspect the interior of those houses. Here, there is no allegation that the land bank's inspector did anything like that.
Can you talk a little bit about your thoughts on whether or not this claim is moot?
I don't believe it's moot. I know that the land bank, or excuse me, the trial court had made some findings about the application of the exclusionary rule. And my recollection is, and Ian can correct me if I'm wrong, is that at some point in this litigation, he filed a motion to strike the photographs that were taken by the inspector on the basis of the exclusionary rule. And I think if that were still in play here, I think that might be moot. But I mean, Mr. Ellaby is permitted to pursue a 1983 claim for damages. That I don't believe that's moot.
Okay, thank you. And then can you speak to whether or not the judge made any analysis or findings relating to whether or not they could amend their complaint.
I do not believe that the trial court made any findings. I think it was sort of implied that amendment would be futile. But I don't believe that's directly stated. And I do want to emphasize here that because the allegations here are that the inspector entered the curtilage of the home to inspect the exterior of the house, and under Widgren and Hirschfuss, that just isn't a Fourth Amendment violation. I don't think there's any way that Mr. Elby can amend his complaint to cure that. So I think any amendment would be futile.
Thank you.
And so a secondary issue here in terms of whether or not this was a Fourth Amendment search is that Mr. Elby alleges that the land bank's investigator trespassed on a separate piece of property to observe the exterior of his house. Now, this matters for two reasons. First, it matters because the investigator simply wasn't on the same parcel of property as the house sits. And I mean, as Ian has argued, there may be some case law that the curtilage of the house may extend onto a separate parcel of property, but Ian hasn't cited a case that directly holds that. Excuse me, Mr. Cross hasn't cited a case that directly holds that. The one case he does cite, US v. Combs, which is 468 F. 2nd 1390. It's a Sixth Circuit case from 1972, dealt with the case of a search warrant. In that case, the police officers had a search warrant for a house that was in a very remote area in Kentucky, I believe. And upon arriving at the house, they found a huge cache of weaponry. And while they were conducting the search, they saw a vehicle that was parked maybe 20 feet away from the house. And then they searched that vehicle too, which happened to be sitting on a separate parcel of property, found a separate cache of weapons in that vehicle. And the Sixth Circuit held that search of the vehicle didn't exceed the scope of the search warrant because it was obvious, given the remote area, that the vehicle parked there was associated with the house where the search warrant was executed for. The second reason it matters is because Ian has to allege, Mr. Elby has to allege that there is a unlawful policy or custom that caused the violation of his Fourth Amendment rights. And here, the allegation isn't that the land bank's investigator trespassed on the property where Mr. Elby's house sits. It's that they walked down a driveway on a property next to Mr. Elby's house. And that indicates that the land bank's policy is, in fact, not to have investigators trespass on properties in order to photograph them. And that leads me into the second big point I want to make here, which is that this is not a lawsuit against the land bank's investigator. This is a lawsuit against the land bank. And in order to make out that claim, Mr. Elby has to comply with the requirements of Monell v. Department of Social Services of the City of New York. It's a 1978 United States Supreme Court case, 426 U.S. 658. And here, Mr. Elby has failed to allege the unlawful policy or custom. He's required to allege that the alleged policy or custom was the cause of his injury. And here, all he alleges is that the land bank investigators regularly commit warrantless searches of backyards in the context of this civil nuisance abatement program. But he does not allege that any policy or custom authorized or caused those searches. In order to get this sort of Monell liability against a municipal entity, a plaintiff must allege the existence of a policy or custom in one of four ways. First, they can allege the existence of a legal policy or legislative enactment, that an official with final decision-making authority ratified the illegal actions, the existence of a policy of an inadequate training or supervision, or the existence of a custom of tolerance or acquiescence of federal rights violations. And Mr. Elby has failed to allege any of these options. Instead, he's essentially trying to impose respondeat superior liability on the land bank for the actions of its investigator, and that is exactly what Monell says you can't do. What's really missing here is any allegation that the land bank authorized, sanctioned, or caused the violation. There's allegations that the land bank uses vacancy data to target properties, and that the land bank's agents regularly conduct these searches in backyards. But it's clear from the allegations in this case that there is no policy that requires these or authorizes the violation of Fourth Amendment rights.
Right, I think that's the piece where he's, was looking in the original action to make an amendment.
Yeah, I agree that, I have to agree that under 2116 I-5, if the deficiency of the Monell allegations was the reason for the grant of the motion for summary disposition, then he would have to have the opportunity to amend his complaint. That being said, I don't know that he can adequately allege that there's a policy or custom just because I don't believe there is one, but obviously that's not a question for the court.
Understood.
And there's another issue with the alleged custom. Mr. Ellaby alleges that the defendant regularly conducts warrantless searches in the backyards of the houses in Detroit, and its agents regularly trespass on property for conducting those searches. However, there's no allegation that the property trespassed upon is the same as the property where the search is occurring. And I mean, that's exactly what you see in this case, where the investigator walked down the driveway that was located on one parcel of property to view Mr. Ellaby's backyard located on another parcel of property.
But he owned both, right?
Yeah, in this case, he owned both. I would say that I don't know how the investigator would have known that without looking at the tax rolls. But yes, in this case, Mr. Ellaby did own both properties. But in terms of the unlawfulness of the policy, this matters because the Supreme Court has ruled a person may not assert a Fourth Amendment violation based on a violation of somebody else's rights. And that's Rockus v. Illinois 439 U.S. 128. That's a 1978 U.S. case, Supreme Court case. In a case like this one, where a plaintiff does not argue that the municipal entity either directed or authorized the violation at issue, there is a requirement that they allege that the municipality acted with deliberate indifference to the possibility that these rights would be violated. That's Johnson v. Vanderkooi, 502 Mich. 571 at 763. And here we just don't have those allegations. And the last point I want to make about the policy is that Mr. Ellaby alleges that the use of vacancy data is one of the things that makes this unlawful. But I think that's actually backwards. The use of vacancy data indicates that the land bank is trying to target abandoned properties.
I mean, I think his point is more towards the fact that it's fairly regularly wrong. That's incorrect, which leads to, this type of situation.
That may be true, but I mean, the land bank's policy is not to pursue these actions against occupied properties. They don't want to bring these snap actions, nuisance abatement actions against occupied properties. And here, Mr. Ellaby alleged through his counsel that he lived in the property, and the land bank dismissed the case. And the reason I think that matters is because if the property is abandoned, then the owner of the property has given up their ability to make a Fourth Amendment challenge to a search of that property. And that's from Pineda v. Warden Calhoun State Prison, 802 F. 3rd, 1198. That's a 11th Circuit case from 2015. And unless the court has any questions, I'm done.
No, thank you very much.
Thank you, Your Honors.
All right, Mr. Koss, you have time for rebuttal.
All right. One thing I want to make clear is that what happened in this case is after we filed the counter complaint, after Mr. Ellaby countersued the land bank for violating his Fourth Amendment rights by trespassing down the driveway on the parcel immediately adjacent to the parcel containing the house, they sent the same investigator to go take another picture of the backyard from the same location. So it's this argument that we didn't cause the violation, we didn't, know that this parcel was also Mr. Ellaby's parcel. Well, they knew after we sued them or countersued them that this was Mr. Ellaby's parcel and that he's claiming that it's his curtilage. And they just trespassed on it again. So I think that certainly there's a basis for an amended complaint there. if the court were to find that the allegations of a municipal policy were insufficient. We don't believe that under Michigan law or that we're required to allege deliberate indifference in this case. But if the court were to find that we are, we should have been able to amend to allege deliberate indifference. Second, with regard to Widgren, I'm going to quote from Mockridge. Moreover, Widgren's rationale likely does not survive the Supreme Court's reinvigoration of the property-based approach, under which a search occurs when a government official, quote, physically intrudes on the curtilage to gather evidence. That is exactly what Gibson did. And Mockridge is in the context of a civil enforcement action, just like this case. The reason Widgren is no longer good law is that in Jones and Hardinez, the Supreme Court reinvigorated the trespass-based approach to Fourth Amendment violations. If the government agent trespasses into a constitutionally protected area for the purpose of gathering information, they violated the Fourth Amendment, regardless of whether the person had a reasonable expectation of privacy. So I think we have a trespass. The trespass is for the purpose of gathering information. For a civil enforcement action or a criminal action, it doesn't matter. And the only real question is whether the trespass occurred in a constitutionally protected area. And of course, what is curtilage is a fact-intensive question, right? We need evidence about, how Mr. Ellaby used the driveway area, how Mr. Ellaby used the side yard, how close the driveway is to the house. Like, whether or not it's curtilage it's not obviously not curtilage on the face of the complaint. So we believe this shouldn't have been dismissed under C8. And if it was, we should have gotten the opportunity to amend. And unless the court has any questions, that's all I have.
Nope, thank you very much.
Very briefly respond to one thing.
No, I'm sorry, you can't. All right, that case is submitted. We're gonna take a break and we will reset. Thank you. All right. Case number 25 submitted. We're going to go back to our original schedule and we are on case number 20. And that is 369063 People v. Helmer.
Good morning, and may it please the court, Jonathan Simon on behalf of Mr. Helmer. I know that the people are not endorsed, so I will make my comments brief. As the court is aware, Mr. Helmer was convicted of assault with intent to murder for setting his former girlfriend on fire. He was sentenced to a term of 40 to 80 years imprisonment. The first three issues suggest that perhaps the trial proceedings were unfair. We don't believe that there was a valid waiver of counsel, that he was denied voir dire, and that he was denied the opportunity to personally cross-examine the complainant, but rather reduced to submitting questions to standby counsel to ask. However, if the court believes that there was fair trial, that these proceedings did pass constitutional muster, we're still left with the question of whether there was sufficient evidence of an attempt to commit murder. Assault with intent to murder is a specific intent crime. Certainly, setting someone on fire is serious enough to warrant a.
You don't think why aren't his statements to the victim's sister, I think it was, and then his statements to the police afterwards sufficient?
I believe that his comments were that he wanted her to suffer and that he used too much gasoline. I don't think that there was any evidence that there was an intent to murder.
But if he knew he used too much gasoline, he didn't make any attempt to call for help. You know, he was aware that that much gasoline might be, you know, deadly. Couldn't somebody infer the intent to kill from that?
No, it seems that that was an afterthought. He says, well, I mean, it's not something that I think went into the formation of an intent, but rather something which occurred to him perhaps later that maybe he could have achieved those objectives by using less fuel. And
He
the
knew how much fuel was in his coffee can. It was a lot. And if it was too much, he didn't have to strike the lighter to. I mean, this is one of the most hideous cases I've ever seen. I've been here 18 years. I mean, absolutely wicked. I mean, I can't believe for a second he didn't know what would happen if he did this. And this woman is some things are worse than death. In 3 months in an induced coma, her eyes are sewn open. I mean, it's 40% of her body is completely disfigured. That's a lot of gasoline on somebody.
I agree that the facts are terrible, but the intent is the focus, I think, and it should not be the results, but rather what went into the planning, what went into the precursor stage of this event, and the fact that he didn't do anything to ameliorate the effects of this gasoline, I think is due to the fact that there was other people in the area who immediately responded. I think that her friend, Mr. Pry, who had come to pick her up from work, immediately attempted to help put out the fire, as did another employee of the Coney Island who attempted to apply water to the fire.
So the person comes over, yells drop and roll, tries, it doesn't work. There's a gap, right? For somebody else to go and get water and come back. Did he make any attempt during any of that time to assist?
No, I think the evidence was that he fled. But the fact is that it did appear that there were other people who were responding and in an expeditious fashion. And certainly flight may be consciousness of guilt, but guilt of what? Guilt of intent to cause her great bodily harm?
But look at, I mean, in his confession at 1322 to 1340, he says, I had my little sister call her and tell her, you don't know my brother. He'll walk up in your house and effing shoot up all you MFers. You don't care if there's kids there or not. If you're effing with him, he will kill you. You know, the way I've always been, street justice.
Well, that may be his sister's opinion of him, but
But those are his words of what he told his sister to tell them. Right? I mean, isn't that the record?
well, this is something maybe that was said before or after, but the focus should be on what happened during. And I think that simply doing what he did, as horrible as it may be, is not justification for the results. I think that
What if I had a deer rifle and I shot you? Right? I mean, don't I know a gun that powerful could kill you? I can't say ever, gee, the more I think about it, maybe I should have used a BB gun. Okay, a little late for that. I mean, I know by the very power of that gun that it can cause death.
Yeah. I aim
And I
for
throw that
I aim
on-
for the shoulder, not the heart.
Right.
well, I think that those are all very good points, but the fact is it depends upon the specific intent of the actor and not the results which were achieved. I think that there was no evidence or insufficient evidence, certainly not, I don't believe, in the light most favorable to the prosecution, that there was a specific intent to murder. And bear in mind that there was a super habitual. So even if it is reduced to the crime of assault with intent to do great bodily harm less than murder, he's still looking at a mandatory 25-year minimum.
Counsel, let me focus you a couple other issues that you raised in your brief that I want to just make sure I understand your argument, understand what the lay of the case law is, and specifically, is there any controlling Michigan case law that says MRE 611A limits only apply to children and they don't apply more broadly?
No, the Daniels case involved a child. It involves CSC, and but it didn't specifically limit the facts, the right of cross-examination to that specific set of circumstances. But that was the only case I think that anybody's really been able to locate on point. It's quite frankly, under the circumstances, it not being a child, it not being a CSC case, the circumstances being quite different, should not be applied here. I think that this was a grown woman. This was a situation where the court can control the proceedings to allow him to ask relevant questions, questions which are recognized by the rules of evidence. And because the fact is that limiting his ability to cross-examine the complainant through his counsel, standby counsel, based upon questions that he submits, I think is insufficient because it doesn't allow for him to respond to follow-up. And so I think it is an ineffective and insufficient way to conduct a cross-examination.
Okay, second question is, I've read the transcripts and I mean, in my notes, the text of the transcript for the discussion that the trial court had with your client regarding his waiver to counsel is like 4 full pages. What else, what more was the trial court, or are you suggesting we should tell other trial courts across this state that they need to do more than this trial court did?
Well, I think that the rule is that this should be something which occurs. This query should arise at every proceeding. Basically, it happened about 18 months before trial. There may have been some minor reference to it at a pretrial hearing sometime in between the initial request or assertion of the right to self-representation and the trial itself. And then there was some brief colloquy prior to the trial. And first, even though the initial colloquy may have been more comprehensive than the ones later, it was a year and a half between that and the trial colloquy, which was, I think, much briefer and much less encompassing.
So what's your argument? Is it the length of time or is it the statements?
Well,
what
both,
controls?
because when he was given the advice by the trial court at the time of trial, I think it was insufficient because it didn't really cover all the grounds which are suggested in the court rule and the case law. And if there was some other advice which had been given at an earlier date,
play that out for me. So pre-trial happens, waives right to counsel, gets set for trial, day of trial, jury selected and paneled, ready to go. Trial court does what you suggest. It's 18 months later, and he says, no, I take it back. I don't want to waive. Then we've got to appoint counsel, and a year later goes to trial. You're going to be in front of us saying, some sort of speedy trial violation.
No, he had standby counsel who would have been able to take over as lead counsel.
Well, then why wasn't that sufficient then the timing doesn't matter. That leaves you with just the colloquy, right? What was stated.
Well, I would analogize this to Miranda, where you initially Mirandize someone and there is a statement or not a statement. And then at a later date, there is again, an interview, an interrogation, and there must be a complete Miranda, again, given at that second occasion. Also, I think that there are a number of factors which were no longer appropriate. For one, he was complaining that he had not received visitation, and that was initially due to COVID. COVID was no longer a factor. There are a lot of things that happened at the first time which were no longer relevant at the trial, which was, as I said, 18 months later.
Okay. I think I understand your argument. Thank you.
All right. Thank you. I have nothing further.
Thank you very much, Councilman.
Thank you.
That case is submitted. So next we're calling case number 21. That is 368-312, People Be Right. We have 2 endorsed.
Morning, Your Honors. My name
Morning.
is Chloe Brewitt from the State Appellate Defender Office on behalf of Mr. Michael Wright. Your Honors, I'd like to focus today on the first issue, the Fourth Amendment issue, but of course, I'm happy to answer any other questions with regard to the other issues. And within the Fourth Amendment argument, I want to focus primarily on the 2 findings of fact that the trial court made that the audio and video evidence shows were clearly erroneous. And the first finding of fact is that the information that would have exculpated Mr. Wright as a suspect of the person that they were looking for came out after the officers initiated the stop. And the prosecutor in their brief talks about how, there's testimony about the officers switching over to the secondary channel, there's primary channel, maybe some of the information was coming out as they were walking up to the car. But what we do know is what the officers testified that they did hear. And they testified that they did hear that they were looking for someone in a gray or silver Jeep. And if they heard that, then the 2 pieces of exculpatory information came out in the dispatch prior to that information. And they also heard that they were looking for a Black man. And the information that there was a female in the car with the suspect came out before that. And that the suspect they're looking for was wearing a red jersey was relayed contemporaneously.
What do you make of the officers sort of in cross-examination I read said, well, I'm not sure they said that it was a woman with him. I thought that was more of a question.
I'd urge Your Honors to listen to the dispatch that was attached to our brief. It's all relayed contemporaneously and quite clearly. And again, they testified multiple times about what they clearly did hear. Again, one of that pieces of information was that they knew they were looking for a specific named person. And that was relayed again after this exculpatory information.
So they testified that they only knew, from my recollection, and you can correct me if I'm wrong, 3 things. They had a name, right? Black male, in a gray or silver Jeep, right?
Right.
I was looking at cases. Can you tell me whether or not this fits into a dragnet and whether or not there's any case law as to whether or not a dragnet is legal in Michigan?
Your Honor, I'm not aware of that. I'm be happy to submit supplemental briefing on that point, but I will say that again, all of this was relayed all at once and contemporaneously, but I would be happy to
But they didn't hear it. I mean, their testimony is that they didn't hear the rest.
Right, that's their testimony, but again, they testified that they clearly heard these other pieces of information and were quite confident in that, and it just doesn't follow that they would have heard only the information that tended to inculpate Mr. Wright and not any of the evidence that would have exculpated
They
him.
were walking to the car and didn't hear it. That can't be because they heard the other stuff, but this information came before the other stuff.
The exculpatory information came before, right? Right,
So they couldn't have been walking to the car and missed that because it came out.
precisely, Your Honor, yes.
So is that not a credibility determination? We have to show, great deference to the trial court.
I
Which
don't-
specifically said that they found the officers credible.
Credible. Yeah.
That's right, Your Honor, and I don't think that Your Honor is
How
necessary.
do we get over that hurdle? How would you tell us to get over that hurdle?
I think you can get over that hurdle by finding that the specific finding of fact that the information came out after was clearly erroneous because of the audio and video evidence that we submitted. I don't think you have to find that the credibility determination specifically was wrong. The finding of fact that the information came out later is clearly erroneous based off the information. And I want to emphasize too that the trial court in its opinion and order stated twice that this exculpatory information likely would have excluded Mr. Wright as a suspect. And so the officers were equipped with all of that information as soon as they walked up to the car. As soon as they walked up to the car, they both testified definitively at the prelim and at the evidentiary hearing. We could see there was no one else in the car, and we could see Mr. Wright was not wearing a red jersey. Their suspicions were dispelled. Sorry?
Hoodie.
It's a red jersey in the dispatch. So they could see that he was not wearing a red jersey.
Oh, it's a jersey.
That's who the suspect they were looking for was wearing a red jersey.
I thought it was a hoodie. Okay, thank you.
Yeah, of course. So they testified definitively they could see that the scope of the Terry stop at that point was exceeded and any prolonging was a new seizure with no exception that applied. And then the second finding of fact, I just want to emphasize that was clearly erroneous is the trial court finding that Mr. Wright told the officers he didn't have his ID. The officers in their testimony in the prelim and evidentiary hearing is somewhat wishy-washy on this. They testify at one point, he says he doesn't have it. They testify he looked for it for a minute but couldn't produce it. They say he couldn't produce it. And again, I want to emphasize this is a less than 40-second encounter. Most of the time is taken up by Officer Wilson telling Mr. Wright the purpose of the stop. We don't have the audio, of course, of their initial conversation, but we do have the responding officer who comes up before Mr. Wright's ordered out of the car. And Mr. Wright very clearly is saying, I've got my ID right here. Here's my ID. After he's pulled out of the car, I was giving you my ID. Prosecutor in their brief states that he's saying this after he's pulled out of the car. I urge your honors to watch the video we submitted with our brief. That's not true.
We've all watched the video.
Okay.
Actually, many times. This has been a hot topic.
Apologies.
This case has been the hot topic.
Mr. Wright very clearly is proffering his ID. And I want to emphasize the prosecutor in their brief concedes that this is a conclusive fact. The officers only had to look at Mr. Wright's proffered ID, see this is not the person they're looking for, and it would have been conclusive. And Mr. Wright, and they exceeded the scope of the Terry stop by not allowing him to do that and by not looking at his ID.
But they're looking for a suspect who may have a gun, right?
Right.
And for officer safety reasons, pulling somebody out of the car, I mean, you don't think that makes any sense and is legal under the case law?
Well, Your Honor, I'll just go back to the fact that they knew this was not the person they were looking for when they saw that the exculpatory information that wasn't present when they walked up. However,
And the woman could have got out of the car. He could have thrown off the jersey. People do things when they're fleeing a scene.
I mean, we've had cases where the woman or the other person in the car was laying down.
Right. Fake beards. I mean, the whole bit.
sure, but I'll say that Detective Flaviani is the officer who came up on the other side of the car, and he said he looked in and could see clearly nobody was in the car. And this is all a quite quick encounter. You know, this isn't a situation where they spotted someone 30 minutes later or an hour later. This is all happening all at once. So I don't think that there would have been an opportunity for any of that to happen. They see Mr. Wright the entire time in his car. They follow him through a couple stop signs. They testify he did nothing wrong up until that point.
He wasn't exactly fleeing at a high rate of speed or anything.
Right, exactly.
Yeah.
Let me ask you just to clarify the record, and forgive me if it's in your brief, but how long after that initial 911 call was placed did the stop occur? Or better yet, when the bolo went out versus the stop?
It was about 2 minutes.
2 minutes? I
Yes.
knew it was short, but I couldn't remember if it was 3, 5. So it's
Yes.
2 minutes.
About 2 minutes, yes.
Close.
It's around 1740 when all the information is coming out, or 1739, apologies, and they stop him at 1741. So yes, it's all happening all at once, and they watch him the entire time.
And he's in the area, right? Like you are in
Yeah.
the area.
That's
Because
right.
he's within like a mile
That's
of
right.
of that liquor store right on Pike.
It's the
I-
general vicinity, yeah.
I had record questions.
Sure.
Can you remind me, was this a rental car that he was driving?
It was, yes.
Okay. And did he have any outstanding warrants?
He did not.
Okay.
No.
Thank you.
One last thing that I want to get your take on before we hear from the prosecutor is, talk to me about the removal of your client and the claim of plain view that the narcotics in the baggie in his right pocket when he's pulled up.
Mhm.
Talk to me about that.
Sure. And we argue in the brief that these drugs could not have been in plain view based off how far they were way down in Mr. Wright's pocket, enough to give rise to probable cause that the incriminating character is immediately apparent. But
So if we're looking again, we've got to look at this through a deferential lens, and that goes away. The plain view goes away when it's based largely on the statement. Where should we look in the video, or how should we analyze that video? Because it seems to me there's sort of three key components where he's lifted out or he's guided out with his back to the officer. Where's the officer's gaze? And then, not just then, but when he turns around, where are those drugs eventually located? I
Mhm.
mean, I happen to be a big hoodie fan. and carry my phone around, and that sinks pretty deep down. So if you equate that to the bag of drugs that were eventually found on him, I mean, that's pretty similar.
Right. And I think all parts of that video should be scrutinized. I think particularly when he's turned around, once he's pulled out of the car, and you can see how far down, the bundle is weighing his hoodie. It's a very thin or slim, opening. You can see, especially once he's pulled up to the dash cam and you can see closer, particularly enough to give rise to, probable cause that it's, that the incriminating character is immediately apparent, right? Up until this point, they testified Mr. Wright had done nothing wrong. They weren't involved in any type of drug investigation. There was nothing else that could have led them to think that a bundle that could have been any number of innocent things was contraband, and they performed an impermissible search to pull it out and do the field test to determine that it was drugs. So unless the court has further questions, I'll reserve my time. Thank you.
No, you did. You have time for rebuttal.
Thank you, Your Honors.
All right, thank you.
May it please the court, Jeffrey Kalen appearing on behalf of the people of the state of Michigan. I would note that I'm handling this for Daniel Walton, who has transferred over and moved over to the Genesee County.
We'll try to be gentle, but
You couldn't keep them, huh? You just,
You know, other than better pay, better position, better title, better office, and closer to work, I can't find a single.
can't find a single reason why,
For her
right?
to leave, we talked, but, and as we all know, I mean, obviously council's brief was wonderful, and Ms. Walton's brief is always very good. There are two corrections I would just note, on page 36, and this is in the area of the drug evidence. There is a paragraph, it's a second full paragraph that talks about Detective Cronin's testimony, and that appears to be from a different brief, because there was no Detective Cronin.
Is that your brief or her brief?
Her brief? I've not
Okay.
written a brief, so the
Okay.
initial,
Yeah,
our
oh,
initial
yeah,
response, I'm sure you noticed it, because the facts did not line up at all with anything else, so it was very apparent, even to me who didn't write the brief. And the second thing is just, I float between the trial division, including trafficking and appeals, and the standard 4 argument, part of it, and our argument 2 addressed a claim that Detective Flaviani's credibility should have been somehow impeachable through the Dilworth case. Interestingly enough, there are 2 Detective Flavianis, or there were in net, and the Detective Flaviani, who I agree with Ms. Walton's characterization, and I have more details if the court wants, but I don't think it's necessary. He was not at fault. He wasn't told about the lab test, the Detective Mike Flaviani in the Dilworth case. However, we have Detective Paul Flaviani in this case, so it wouldn't be
Different
impeachable.
Flaviani.
Yes. they're
Related?
I believe they are, but I don't remember. I remember asking Paul that at one point, the one that was on our case, but
Father, son, perhaps?
yeah, no, I think a cousin or something,
Okay.
like something distant. With that, I would,
well, I'll ask you the
Sure.
same question I
Yes.
asked her. If the only information that they acknowledged having before the stop was black male, gray or silver Jeep, is that enough information to stop people?
well, it's a lot like, I think, the drug where you have the verification information. They didn't stop every black male in a gray Jeep anywhere. They responded to the location where this was going on within a minute or two. I think she says 2 minutes. I know they testified around a minute. So they're responding to a highly dangerous situation. Again, a man chasing a woman with a gun. So this is something where they have to take very seriously to protect everyone. They're not looking for drugs, as counsel correctly noted.
So
They're-
they would have been okay stopping every single black man in a gray or silver Jeep in that same vicinity over what period of time?
Well-
Like 1 minute, 5 minutes, 10 minutes, an hour?
Speculating as to how far out, I can't go, but certainly when they respond to that location and they see a vehicle matching that description, even if they didn't see who was in it, and there's no other vehicles that appear to be matching that description, then that I think would be enough for them to further investigate. They say, yes, this is a black male, and as the Judge Kelly mentioned, some of the information that came out later, which again they said they hadn't heard, and we'll touch on that in a second. But if they respond there, they have to resolve it. If that vehicle is there, that appears to be it. There's no other vehicles out there. If there are 3 vehicles that all matched, it might be a different scenario. But you arrive in that location, you go, okay, we got to figure out what's going on to protect. And then, okay, here's a vehicle. This matches. Let's stop it. Let's look. They interact with this individual. And again, once he says, which I know they dispute, but it ends up being a credibility question, that he says, I don't have my ID. And maybe he did look for it first, but their testimony was that he said, I don't have my ID. They bring him out. And yes, I understand that apparently he said, oh, I do, which happens sometimes where they don't want to disclose who they are.
Didn't he have it right on the door?
I believe it was in the vehicle, but I would have to look at
I remember it being like, so that he took his ID out, put it there and put his hands up. And it was right there and they didn't let him turn it over. Is his contention.
Is his contention.
Is
Their
his
contention
contention.
is they asked him and that he said, I don't have it, is not entirely terribly unusual for people not to want to identify themselves to police for
That
a number of
statement he
reasons.
gives kind of defiantly, I told you it was right there, man. I mean, that
Yeah, you hear it on the
That
dash
that's
cam.
certainly is, pretty strong statement from a guy that I'm giving you the ID, not cooked up later. But right at
True,
the
and
time.
perhaps he said it, and when they decided, okay, we're taking you out as a result, then things changed. I mean, these things do absolutely happen where you respond.
Let me ask you, so just based on what you were saying, is your position that under our Constitution, if within 3 minutes of within a mile of a crime, if you've got a description of a gray or silver Jeep, they can stop every gray or silver Jeep? That's all the information the police need.
I think it depends on the nature of the crime and the nature of the other vehicles around and the nature of their response. Here, again, a minute, 2 minutes, they arrive at the location where they would expect to find the vehicle.
So let me just slow you down.
Yeah.
So 3 minutes, you got to pull over within 3 minutes, within a mile and a half. And if all they had was because you said, you got to stop because sometimes they can't see. So is your position is under the Constitution, if police have a description of the vehicle, gray or silver Jeep, which isn't even a specific model, but it's just a make, right? That would give a broad swath of gray or silver things, right? And I think, and the reason I ask is because I find it notable that these same officers passed a silver Chevy right before this and didn't stop the person.
Right. And the problem with these types of scenarios is you often have limited information, sometimes not entirely accurate information, but the information you have is what you have to go with. So in this case.
But they actually did have the other information. They just didn't hear it, right?
Yeah. And that's something, again, that yes, it was broadcast and we have the recording of that. But again, in a patrol vehicle, the reception is always not always wonderful. They could have been talking about it. They could have, the minute that it came out, they could have said something and then hadn't heard it. There's a number of scenarios where they're saying absolutely truth. What they're saying is absolutely truth and yet not inconsistent with everything else.
No, I just bring that up because dispatch did give actually quite
Yeah.
a lot of information.
Right.
Yeah.
And again, once they leave, there's a lot of
While they were
aspects to it.
talking, there's nothing that stops them from saying, sorry, can you repeat that?
True.
True. But then when they see it within a minute, say, okay, there is a silver gray Jeep, I should say, gray Jeep, black male, matching it. There's no, again, if there's other vehicle, it's a totality of circumstances in a sense.
Let me ask you a different thing, see if we agree on things. The seizure of the drugs hangs entirely on your officer's testimony that it was in plain view. Is that correct?
Yes. Yes and no, actually, because yes, because his license was ultimately found. When he said, I didn't have his license, or, he said, I don't have it, that would have been a misdemeanor. They're allowed to take him out. Again, if they can verify that he does have it, then I would say that would be no longer a viable thing technically.
Okay. So
yes.
the seizure hangs on the plain view and the testimony of this officer.
Yes.
Okay. You've watched the video
Yes.
numerous times.
Well, I wouldn't say numerous.
But you've watched it, right?
Yes.
At what point in that video, go screen by screen, is your claim or the prosecution's claim that those drugs were in plain view?
Well, one thing I've learned with videos in general and unfortunate humanity in specific, well, first of all, your visual is always better than the video recording. And the video recording is from a particular location. When clothes move, and I say unfortunate because I'm part of the trafficking division, there's a whole thing about videotaping people as they move around. And while they might be clothed at one point, when they bend over, when things happen, clothes bunch up, clothes move, and you can see into things that you shouldn't be able to see into. In this scenario, you can see as he's coming out, it's weighing down. Like you can see there's something there, and the officer is right by
Way
him.
down, like it looks heavy and low.
Sure,
And
but
he's a big guy.
And we-
It's a big, it is really hard to, I mean,
And yeah, where I struggle with is the officer too, is when you watch that video, the officer's gaze is straight up. And if anything, he's looking over at his partner above the car roof or into the car. He's not leaning down. He's not looking over. He's not like this. I mean, his body is up, hands on the shoulder, guiding him out. So that's why I struggle. I mean, he's got visual impairment of his arms from the obstructing the view. Those are some of my questions because look, the standard of deference, what we have is, yes, we give deference to the officer and his testimony. The trial court found it credible, but we also have to look at the other record evidence to see if that was a plain error based on that to contradict it, right?
and we do have case law that says if you have video that plainly contradicts, the facts that have been testified to, that a Court of Appeals can take that into consideration.
Right, absolutely, yes. But again, I think there are levels and levels to that. If you have a video showing this is exactly what occurred, and the person said, no, there were two other vehicles there. Oh, there was clearly not two. In a scenario where he's interacting, yes, he might be facing this way, but he's looking everywhere. Remember, this was a gun case. This was someone had a gun. He has something heavy in there. If he's moving around to the point, which is the officer said, that opened up so that he could see, all he needed to see is what's a clear baggie with off-white baggies inside it. That's not hard to see. He's been a drug officer for many years. You see that, you go, oh, those are drugs. That's all it is.
Remind me, when did, this is Wilson, right?
Yeah.
When did
yes.
he say he saw the baggie?
I would have to.
I think he said when he was pulling him out of the car.
He said it was
Yeah.
as he was pulling him out of the
Yeah.
car before he handcuffed him. And he handcuffed him almost instantly.
Right. And you got to understand, like, there's not just one thing that's like, it's that all of this information, they had his name, black male, red jersey, woman in the car, that they only heard two things, silver or gray Jeep. They only heard two things. Okay. You can hear it yourself because you hear what they
Right.
say.
Well, you can hear the broadcast.
So
Right.
we have to believe that all those other things weren't heard. And then, you get the stop and you get the contradictory license, no license. He said he didn't have one, but then we hear the dash cam and, that's kind of like Judge, like my colleague said, he was protesting he was like, I told you I had my license right there. I had it right there. And sure enough, that's exactly where it was. And then you have, the video situation where he's like, oh, well, they were in plain sight. I saw them, but he's not even looking down. It's the totality of it that's making it difficult to do you understand where we're coming from?
Yes. But again, where his head goes, again, a gun case is not necessarily where he's looking. They'll stare here, they're looking around, they're doing things like that. And again, we've all had the hoodies where there's the front pocket. When you move around, that opens and closes as you
I
go.
don't think it's, we'll have to go back and look at the video, but I'm not sure his hoodie was I thought it could have been a zip up one. Or
Well, I mean, it has the,
but it's
I thought it
different.
was, yeah.
It's different.
And what
They-
was weighing it down?
Well, the drugs, I thought.
Was there a
Pulls them out,
scale
they
or
don't-
something?
No,
Oh,
scale
that was
was
in
in
the
the
car.
vehicle. Yeah, scale was in the center console.
I'm just saying,
as
but if he saw it, and correct me if I'm wrong, this is day two, I always get a little muddled. But
And 19 cases yesterday. I don't know why you would.
if he said he saw it, I think when he was getting him out of the car, he doesn't say anything about, hey, what's up with the bag in the pocket, right? And
Yeah.
it seems like in many cases, they'll say something right then. Hey, tell me what's in your pocket. All right, what's in this bag? I'm looking
I
at.
can't speculate as to what was in his thought process. They're
See,
certainly
it's all
getting
these
out.
little things that individually, woman in the car, okay, she could have got out.
Right.
But you add up all of this stuff and there's something about this that just doesn't feel right. The
Oh.
totality of it.
Understood, but at the end of the day, again, they had a BOL and it did matter. Very serious circumstance. They responded, they were there right away. It's not a case of multiple vehicles there. They see a Jeep that matches it with a person driver that matches the description. They interact. I don't think there was any dispute as to them identifying the reason they were asking for his ID, that they had the identity of the supposed or suspect shooter. Certainly if he's saying, I have my ID, you would think he would have also said, I'm not the person, whatever I'm so-and-so, or saying his name. He didn't do that.
Let me ask you a different question.
Sure.
If they would have stopped the first car, silver Chevy, and all this transpired, would that have been okay?
Less so, because again, of the few details I have.
Yes
it's
or
not
no?
Consistent. No,
Not
I
less,
would,
less or more. I mean, Constitution,
Well,
would it be
again,
okay or no?
I would say that would be more troubling, because again, the only match would be the color of the vehicle. Yeah, I would say probably not, because of what they have to go with what they have, and they have grayish Jeep or gray silver Jeep. And again, a black male. So it's driving away. It's a silver vehicle. They didn't say any silver vehicle, Jeep. Okay, we can restrict it to that and then go from there. But again, if there's 3 Jeeps, it would be different. If it was, 4 Jeeps, then they would have to potentially do it, because they would know for sure they're not all the same person. But here they're responding. They want to try to clear whatever's going on. So the stop, based on that information, again, we feel is okay. And the stop, they wouldn't necessarily have known, and until they got out and interacted. Okay, there is no woman there, and okay, there is no outward jersey. My understanding is he had a red shirt. But at that point, they're already interacting, and again, pulled him out when he said, I don't have my license. Again, yes, he did say afterwards that, I have it, but identifying the reason that they were there, we're looking for, a person by this name.
Did he say it afterwards or before he's out of the car?
My recollection was they announced the reasons for the stop initially, like when they were interacting with them. That's at least my read of the record as far as that goes, in my recollection of the events. But yeah, that's my understanding was they announced, they described that in the beginning, and then they asked for it, and he said, I don't have my ID. And again, there's a lot of people that say that because they don't want to disclose who they are. Maybe when they decided we were coming out, we're going to arrest you, they say, oh, I do have my license, I do, blah, blah, blah. I mean, that's not outside the realm of possibility. At the end of the day, these officers, again, I know it's a credibility contest, and I know the court has concerns, but at the end of the day, being on the street and seeing this is a lot different. Again, what we see in a video from a stuck camera going forward is a lot different than a person right there watching the person getting out, watching the clothing folds, watching everything else. It's a different scenario.
Well,
So,
that's why you need to make sure that your audio is working.
yes, I mean, I teach.
I mean,
right.
you're adding, I mean,
I
I'm
know,
sorry,
100%.
you're past your time, but
Okay,
adding to all of that, there's no audio from him, but from the other car that comes up, we get it.
And we teach them that. And we also teach them, please turn it off during bathrooms, because that happens too. And it's just, but yes, right. And but we have what we have, and we have a credibility without anything directly contradicting. But
Fair enough.
thank you all.
Thank you.
Your honors, I have nothing further unless you have any more questions for me.
Thank you. All right, that case is submitted. I'm gonna move on. Number 22-372-524, ECI Environmental Consultants and Engineers versus House of Province.
Good morning. My name's Robert Levy. I represent ECI Environmental Consultants and Engineers.
Morning.
So the big picture here is that the main issue was 2-part. Did ECI create the application and the work plan for the brownfield grant? No question about whether they did the initial assessment or were paid for it. There's no question that they were discharged before the actual physical work pursuant to the grant was performed. It's just about creating this application and the work plan. And as I've stated in my brief, even after Dr. Stokes, who's the principal of ECI, testified, and at the end of his cross-examination, ECI's case was going with flying colors. The judge stopped the defense attorney in delving into a certain area. And the court said, well, and he's talking about whether ECI performed the application work and work plan. She says, well, but he did everything. And there's no dispute that he did everything to get the grant. I mean, his name is on everything. So at that point, it's pretty clear that not only based upon Dr. Stokes's oral testimony and credibility, but on documents with his name on it, the court was convinced that ECI did the work to create the application and the work plan. Where things took a wrong turn, and I would contend that this is the main issue, the main question that the court got wrong. And if the court had gotten this issue right, every other proceeding about these invoices from the subcontracting consultants would have been totally unnecessary. What happened was, in Dr. Stokes' testimony, he wishes to introduce his own invoice, ECI invoice, covering his work and the subcontractor's work. And the defense attorney objected because it had numbers, charges from the subcontractors. And she said that's hearsay, it's information from a third party, and it's inadmissible. The judge at that point, there were other arguments made by the defense counsel about the trustworthiness of the invoices, because Dr. Stokes created it after he was discharged, that he created it in one day. Well, he created it after he was discharged because Pastor Dunn had told him he didn't have the money to pay for it going all along. So Dr. Stokes did him a favor by waiting to bill it. And Dr. Stokes did make notations about the work as he went along. And he said his business practice was to make these notes and keep them and then create the invoice from them. Defense attorney said, well, it's untrustworthy because he doesn't have.
But doesn't 8036 require that the record was made at or near the time of the transaction? And you just stated that it wasn't made until after the work was done, and that he did him a favor by basically holding the invoice.
Well, the work went
time later.
on just basically under a year. So it was near the time the work was done.
So your standard would be anything made within a year as an accurate business record, even after it was made after the dispute arose, correct?
Yes.
Do you have any case law to support that?
Pardon?
Do you have any case law to support that? That a year after is the definition for near the transaction?
No, I don't think I mean, it's a case by case basis, I'm sure. But he has a reason for not.
But you would admit that it was created after a dispute about paying him arose, correct?
Yes,
Okay.
yes.
So we're supposed to ignore, I mean, how does that feed into or provide color to the trial court's credibility determinations, which we have to give deference to?
That was not the main reason that the judge found it incredible. It was because one invoice at the hearing subsequent to trial had a current date on it, and she had said she wanted the original invoices. And as I stated in the trial court and in my brief, this was a computer issue where the subcontractor didn't realize that every time he reprinted an invoice, the software would put the current date on it. And in fact, so that was the main reason. The judge was okay about everything until then.
But the reason that the rule requires that the business documents be made contemporaneous to the action is because of the reliability issue. I mean, that's why you know, we're trying to, it's an indice of trustworthiness.
I understand. In this case, up until the time when this invoice showed the current date, the judge found Dr. Stokes's testimony totally credible, as I just quoted from it.
But that was half the case, right? Like that was the first half of the case.
Right. Right.
Yeah, the other side hadn't presented yet.
All I can say is, at this point, there was no reason for him to issue an invoice when it wasn't going to be paid. He was doing Pastor Dunn a favor. And he was following his regular business practice. He wasn't making an exception, you know, where,
I mean, you don't get paid for favors. You know, if he was planning on charging him later, that doesn't make sense to me. If it was a favor, that makes sense. And then the favor goes away because he doesn't get hired.
no. The favor was waiting to bill for the work that he actually did before he was fired.
So then wouldn't you want to keep records as you go so that you don't miss bill later? If you know you're not, if you're
Well,
going to, particularly if you're going to hold on.
Those notes, those records to create the invoice. It was after he created the invoice that he discarded them.
So doesn't your favor argument though then undermine your oral contract agreement argument? Because if he was doing them a favor, the agreement was, I'm not going to bill you.
No, he didn't say that. He said he waited to bill because Pastor Dunn was expecting donations because it's a charitable organization, religious foundation. By the end of the year, he was expecting to have a big benefit and take in a lot of money. So he asked Stokes, please wait, I'll have the money after I do that.
Okay, but there was no specificity in terms of what work was to be done, when it was
Yes.
to be done. When was that? Where is that? That's all just your client's testimony, right? Because that's not what pastor said.
Well, when this case was before the Court of Appeals before, it was on appeal because the judge dismissed the complaint on the basis of the statute of frauds. But this court said it was an oral contract. And yes, there's certain requirements it has to state, but the court indicated there could be an oral contract. Because
Right, okay, so that's what I'm asking is what, cite to me specifically in the record, the evidence supporting, or the testimony supporting all the requirements for an oral contract.
It was Dr. Stokes's testimony that he walked the land with Pastor Dunn, showed him everything that needed to be done, told him his hourly rate was $195 an hour. He would bill by the hour, and there would be an overburden consisting of his expenses for supervising the subcontractors, having insurance, and a profit margin.
But that's like to ultimately do the work, which he didn't.
No.
That was just to create the
Yes.
grant application?
Yes, because he wouldn't know exactly how much money was available to do the work until the grant application was accepted and he knew how much money House of Providence was going to get.
Do you know how much House of Providence ultimately paid somebody for the grant application? For doing the work to create the grant application? That's what you're suing for, right?
Yes,
Okay. How much did they end up paying somebody, if not your client?
I think they said they paid like $2,000. Well, that was because ECI did all the work. You know, there was,
So, but let me just go back for your oral agreement, doesn't it really came down to a credibility testimony between your client and it came down to Dunn and Stokes, their testimony, right?
right?
So isn't that a credibility determination that the trial court makes? Says I find Dunn believable, I don't find Stokes believable.
The problem with that perspective is that the trial court totally changed its mind about Dr. Stokes's credibility because of the date on one invoice that was submitted after trial.
Isn't that their judgment? And didn't you request the ability to submit the invoice after trial because there
No,
was a
there was
dispute
the
about
judge
it?
that suggested that. But what I want to go back to is that when the objection was made by defense counsel to the invoices, because it included charges by the subcontractors, and the subcontractors were not there to testify to what they did and what they charged. ECI's attorney asked the judge to overrule the objection because the charges of the subcontractors, their invoices, have been incorporated in the business records of ECI and become part of their business records and admissible as such. And that's absolutely the law, at least in federal court, on which our rules of evidence are based. There are, as of November of last year, 9 circuits have said, and let me quote from one of the more recent cases. And this is the case in federal court downtown here. Harris versus World Financial Network National Bank. And this was a situation where the defendant wanted to introduce these applications for credit that were not, were submitted to a company that was adjunct, but not the same as the plaintiff. And the court says, this is on, and this is 867 F sub second 888. The court says on page 899, quote, the custodian of records need not be in control of or have individual knowledge of the particular corporate records, but need only be familiar with the company's record-keeping practices, unquote.
Right, but wouldn't you agree 803, let's set aside whether they were incorporated in or not. 803 requires the court to consider its overall trustworthiness, right? That's an express condition of admissibility, that circumstances, creation of the record, you know, the other side can object and say, hey, there's circumstances that undermine the trustworthiness, which is what happened in this case. So then the court said, you know, I kind of tend to think that, so why don't you come in and lay the foundation for the trustworthiness and the credibility of the subcontractor's work and invoices. And then when that happened, instead of increasing the trustworthiness, the trial court found that it decreased the trustworthiness.
Well, first of all, when the judge issued the order that said there's something that looks amiss with the date of these invoices, at that point, ECI's counsel really didn't know what she was talking about, but he submitted a supplement with not only all the invoices, and the one that's at issue had the correct date on it, was the original invoice. He submitted emails in which the subcontractors sent their invoices to ECI, and he felt that had to cure any issues about whether
Well, correct me if I'm wrong. Didn't the judge give ECI the opportunity to bring the contractors in?
no.
Okay, all right.
And it wasn't necessary, according to this rule in that same case, it says 900, page 900. Moreover, the fact that defendants incorporated data from a third party does not affect the application of the business record exception. The defendants, the information obtained from third-party retailers is essential to defendants' regularly kept account records. Records need not actually be prepared by the business to constitute business records, so long as they are received, maintained, and relied upon in the ordinary course of business.
Do you agree and concede that as a trier of fact, the court had the ability or the discretion to believe or disbelieve the evidence put on by your client?
The problem is that that rule applies when the judge is assessing the credibility of someone's testimony. When she was assessing Dr. Stokes's testimony, she was all for it, as I read initially. She did this because one invoice had a current date on it, and she not only didn't allow the plaintiff due process notice of exactly what she was concerned with, and that this was a
But-
dispositive issue for her.
But your client turned that in, so your client should be on notice of what he turned in.
I agree. But the point is, that what I'm making is this whole rigmarole about the invoices, it was absolutely irrelevant because they should have been admitted initially.
But wasn't that part of how that happened was during the laying of the foundation for the admissibility of the business record? You don't just get to say this is a business record. You have to lay a foundation that this is a business record. And the foundation that was laid by your client was they created all of these out of whole cloth on one day. I shouldn't say whole cloth. He explained how he created them on one day based on some notes. And as part of that foundation and laying of the foundation, that's in part what gets examined, and gets pushed. And the court says, look, I'm giving you an opportunity to lay a better foundation, bring in the subcontractors' invoices. And then when those came in, that undermined the credibility and the trustworthiness.
But the subcontractors' invoices and the genuineness of has nothing to do with Stokes having created the invoices on one day from notes. They're two separate issues. So evidently, if the judge was interested enough to see those invoices, she wasn't concerned with the rest of the objection to admissibility because it wouldn't have been important to her to look at the invoices. And she admitted that she never looked at the supplement that had all the correct invoices and the emails transmitting them. She never saw that before she ruled that Dr. Stokes's testimony was totally incredible because of a date on an invoice. And the major part of ECI's invoice.
You would
Was
agree,
that-
though, he based it on his field notes and he destroyed those field notes before trial, right?
He did after making, because you're implying that he did it so he wouldn't.
Well, I'm just asking.
No, no.
That's a
He
matter of
destroyed
fact.
him after he sent the invoice.
Right, but that was before trial.
It was before trial, but at that point, he didn't anticipate litigation.
Even
Mhm.
though they'd already had a dispute about whether he was going to get paid or not. Because the dispute arose, then he sends the invoice.
Yes,
He gets fired, then sends the invoice, then destroys his notes, and eventually litigation follows.
yes.
Okay. I just want to make sure I had the facts correct.
So my point is that the judge had in her possession the correct invoices and the transmission, but she didn't look at it before she made her judgment. And her judgment wasn't based upon the credibility of Dr. Stokes's testimony. It was based upon a date on a document that she didn't even allow Dr. Stokes to say, I don't know what's going on here because I've got the invoice right in front of me and it's got the correct date back in 2020.
Did you want to save some time for rebuttal?
Pardon?
Did you want to save some time to rebut his argument?
Yes.
You might want to wrap up.
Okay. The majority of charges on ECI's invoices were from Dr. Stokes and from a subcontractor, Hewlett, who Stokes worked with daily. And the judge did not have any problem with those included in the invoice. It was the other subcontractors. But she threw out everything, I don't think she should have thrown out anything, but she should have at least said, well, I accept the credibility, Dr. Stokes, of your charges and of Mr. Hewlett's because you supervised him.
Also, again, that's a credibility determination.
Well, she let it in. She must have felt it was credible. So I'm asking the court to remand for a new trial or partial trial. In the alternative, if you want to get into the deal, the questions about what happened when the one invoice had the wrong date, then I'd ask for a remand for an evidentiary hearing so I can put on live testimony based on the affidavits I submitted to the court, a motion for new trial, in which I submitted to this court and a motion for remand. So I can put in the record acceptable proof that nobody was trying to deceive the judge. It was a computer error. Stokes never even got a copy of that particular invoice. It only was sent to his attorney because his attorney couldn't find it. And the subcontractor printed it out, not realizing that it would put the current date on it. So it was totally innocent. No one was trying to deceive the court. It didn't have anything to do with Dr. Stokes' credibility. It had to do with the date on an invoice. And I think that considering all the other evidence, the verdict was against the weight of the evidence.
You were the counsel down below, correct?
Pardon?
You were the same attorney
No.
down below? No,
No, it
different.
was
Okay.
not.
Okay, thank you. Okay, so I think you heard the questions and the things that we're interested in. What do you have for us today?
Yes, Your Honor, Christian Huffman on behalf of defendant House of Providence. I was tried to be as thorough as I could in my brief. I have
You
not
were.
heard anything from plaintiff counsel that has caused me to think of something different that I could say than what I addressed in my brief. If the court has any questions, I will try to answer them. I would just say, I agree, with the court. It was a credibility determination. Their story was, we told them we paid them all this money to do this application and they performed all this new work. Our version or our theory of the case was, no, we told them we're out of money. We cannot hire you to do any more remediation work. They come to us and say, which they'd never said before, there's this grant you can apply for. We'll do the application and the work plan. If you get the grant, then you can hire us to actually do the work. And they actually, Dr. Stokes admitted on questioning from his own plaintiff attorney, because we knew that was our theory. He says, so one of the incentives to prepare the application and one of the incentives to prepare the work plan is to get the job being the consultant, to get the $770,000. Yes, that's true. That's page 111 of trial transcript 2, February 22nd, 2024. Judge Valentine then herself on page 125, so just 14 pages later, she asks him, so what numbers would I back off for not having to perform the work? She's asking him, what part would ECI get itself after it paid the subcontractors it wanted to hire? He says, of that $770,000, I think maybe $270,000, almost the exact amount that they were claiming in their invoice. She was also presented with a copy of the application that they claim they did all this work to prepare and they hired all these subcontractors. When you read it, the only thing that they ever reference is work that they did between 2017 through 2019, which they admitted to Judge Valentine they had already been paid for. They say from April 2017 through June of 2019, ECI conducted environmental assessments, investigations, response activities, and due care activities, and analyzed more than 2,000 samples for lead across the 118 acres. Nowhere in this application do they ever make reference or talk about any work, new work that they performed that was done by any of these alleged subcontractors. So I think at the end of the day, it comes down to Judge Valentine knew the theories of the parties. She heard his side, she heard our side. She simply did not believe that there was any contract, verbal or otherwise, where we were going to agree to pay them $280,000 to do an application and a work plan that never got approved. She also heard the testimony from the representative of Eagle that under the grant, the most that they could have ever charged was $2,500. She believed our theory that they offered to do it because they could put together the application because based on the knowledge and the work that they had already performed and paid for, because they were hoping we would get the grant and able to then contract with them and they would make the $770,000. If the court has any questions, I can try and answer them.
No, thank you. Very
Thank you.
succinct.
I think it's pretty clear that the judge's assessment of this case totally changed because of the date on one invoice. I think the way she conducted things violated due process, and therefore my client deserves a new trial on that point. She didn't say specifically what bothered her about the invoices. She didn't say that it was going to be a dispositive issue on her part. The trial attorney for ECI obviously didn't know exactly what she was talking about because he submitted the emails transmitting the invoices. And then when both the trial attorney and Mr. Stokes were flabbergasted by what the judge was saying, and Dr. Stokes is saying, I don't know why you say that that date is on it. I've got the invoice right in front of me from the subcontractor, and it's got an October 2020 date on it, which shows that he never in fact got possession of that particular invoice with the wrong date on it.
Oh,
Moreover,
wasn't counsel, wasn't
she didn't
counsel,
get it.
counsel, excuse me. Wasn't there a pre-hearing order entered after your first post-trial filing that said that specifically advised your client of the concern with the authenticity of the subcontractor's invoices?
I don't recall the exact language, but there was something that said, I'm concerned about the date, perhaps, or maybe it was authenticity. It could have been.
But the date, so clearly that was an issue, and the subcontractor's invoices were a central problem in the case. So I'd like to see how there's any due process violation here. I find it hard.
She didn't give specific notice of what the issue was. She didn't give notice that it was a dispositive issue for her. And she didn't let Dr. Stokes and the person whose computer created the invoice rebut. It's like she raised the issue and then gagged Dr. Stokes, couldn't rebut it. I don't think that's due process.
But your client submitted the invoice that caused the question, right?
I think,
Like, why is it not just, sort of user error where your client could have reviewed what was submitted to the court and gone to the subcontractor and said, hey, dummy, your computer printed it out with today's date. I need you to print this out in a way that shows the date you originally sent the invoice.
but my client never saw that invoice.
He submitted it as he
didn't, his attorney did.
Same thing.
Isn't that one and the same?
I still think that the judge should have given an opportunity to rebut. I mean, it's very handy just to be able to accuse somebody and not let them speak out. And that's what happened. Not fair.
Understand your argument.
Yeah, Dr. Stokes said, of course, he wanted to do the physical work from, as specified in the application. But that doesn't mean that he didn't do the application work and the work plan. The application referenced the assessment, but it wasn't necessary for the application to outline what work Dr. Stokes did to create the application. That was irrelevant. The application itself was what was important. The application, there was some minor details that needed correction, and the representative of the State Department of Environmental Quality said that's common. It doesn't discount the work that Dr. Stokes did to create the application and the work plan. It just means.
Counselor, are there any, other than you're re-arguing a lot of the same facts and a lot of the same stuff we've already heard, are there any legal issues, not credibility determinations, but legal issues that we need to pay particular attention to that we haven't already discussed?
That's rebutting what the other attorney said,
I
what
am.
brother counsel said.
Well, I was, because he said all those things. You know, I would say that it was a mutual stake for the defense attorney to say that she never got the invoices during discovery. I've submitted proof that they were, and the defendant has not disputed that. So it's really irrelevant though, because the invoices, the physical invoices didn't need to be entered at all in order to substantiate the ECI's invoice. So it's really a moot point, but I do mention it in my opinion.
And you have 1.5 minutes.
That's all.
All right, thank you. That case is submitted. Number 23, 373-748, Kermit Lamarck Copeland versus Allstate Insurance Company. Parties may approach and begin, place their names on the record.
Morning, ladies and gentlemen. Attorney Mike Ford is here on behalf of the appellant. Shall I begin?
Please.
All right, I think the issue is pretty straightforward and simple. We've got, it's a domicile issue, as my brief lays out. The issue is whether or not Mr. Copeland, who had not lived with his sister for nearly 20 years before this accident, was in fact domiciled at her residence. Mr. Copeland indicated clearly unequivocally that he hadn't been there in a number of years. He submitted an affidavit that reflects the fact that he'd been in a number of domiciles since that time he last lived with his sister, and that period of time was about 3 months. What I want this council or this panel to recognize is that I believe there's sometimes cultural issues when you live where, or when you're in a family where there's only one family home per se. You may use it as your mailing address, but that doesn't make it your domicile. And I think that's what we had here. I mean, his sister's a lawyer. She's an established person. She's got a family there. She's got a husband, and in this particular family, she was the only person that had a home. Mr. Copeland has had a number of problems, but he's in the 20 years or nearly 20 years since he lived in her house or stayed with her for a few months. He's had, like his affidavit indicates, he's rented rooms. He's had rooms with girlfriends, lived with girlfriends. He's had a lot of places he lived in the 20.
Was he in prison for a while too?
He went to prison for a while.
That sounds like might fit the criteria of a domicile.
Right, and so that's the point I'm making. There was no intent to return there permanently, or there was no living quarters there, no keys to the house. There's no evidence that he even had dinner in that place in 15 years or so, 16, 17 years before this motor vehicle accident. And so I think the judge made a mistake. And at a minimum, it should have been a question of fact. The second issue that I think that I want this panel to be cognizant of is this. As I indicated, his sister's a lawyer. She's and her husband have, over the years, filled out a number of applications for insurance and have indicated that only their family lived with them, and that doesn't include Mr. Copeland, the extended family. That being said and done, where counsel or what the insurance company's arguing potentially exposes her to, attorney's grievance issues, because it almost implies that she be mischaracterized or lying on her applications for insurance as well. She's testified that he didn't live there. Her husband testified he did not live there. Mr. Copeland testified he did not live there. There should have been a fact question. And I'm going to wrap this up lastly by saying this. The other issue that the judge didn't address is the fact that the insurance company, I believe it's Farmers, that the sister and husband had, was not a party to this matter. And their rights should have been included or protected by virtue of the court's ruling as well. I mean, I thought they should have been brought in as a party minimally, but I honestly believe that the MAIPF should have paid the claims and then sought subrogation.
Were you trial counsel?
Yes.
Yeah. Now, could you have brought her in then? Could you have?
If I believe that they had any culpability, maybe I could have. MAIPF certainly could. They've got 2 years from the date they last paid a claim. Problem is they didn't pay any claims and they didn't assert this argument until several years after the lawsuit had been brought, or a year and a half, 2 years. So the reality of the situation is, no, I couldn't have brought him in unless I believed it at the beginning. And I didn't have any evidence to believe that he was domiciled in the sister's household. He hadn't told me anything about the sister's household, and there was no other evidence. I mean, that was something that came up as against a defense late after the discovery process. All right. Okay, so if you all don't have any more questions for me, I'll sit down.
All
Not
right,
short, succinct. Okay.
so we got it. Thank you.
Good morning.
Morning.
I'm still a little shook about that earlier case where he set his girlfriend on fire. I represent Allstate, the assigned servicing insurer of the MACP. A couple things I want to point out. One, when you fill out an application for benefits, they don't ask who's domiciled there. They ask who resides there. There's a clear difference. I laid this out in my brief between residence and domicile. You can have multiple residents.
We understand that. Yes.
Okay. The Supreme Court, and I know in the Grange case, it's the the leading case on this, says every person has a domicile and that domicile remains until you get a new domicile.
Well, that seems to me the most wildly overstated statement in Michigan law of the last several years. I mean, and Grange, we're talking about child custody, joint custody between the children, can they have two domiciles, right?
Right.
But let me just give you a couple of examples.
Sure.
What if I'm legally evicted? I'm renting from you, okay? I'm a bum of a tenant. You get an order from court to evict me from your house, okay? I'm by law prohibited from going back there, right? I'm sleeping out on the street. I mean, what's my domicile? I mean, that seems to be a person of no fixed abode at that point. They don't have a domicile.
No, the court, under the No Fault Act, the Michigan Supreme Court was crystal clear on this. Everybody always has a domicile.
Well, I'm trying to challenge that with you. Who is that? Where is that person's domicile?
I don't know where they were before they had the apartment, but their domicile would still be the apartment. I mean, you have to go
Even
through
though
the.
they're legally evicted from it and by law cannot return to it. That's one of the factors, right? The place you might want to return, you keep closed. I mean, this mail business is but one factor, right?
Correct. Yeah, the workman, Dairyland factors, there's 9 of them that we went through.
But
with the trial.
the law, I'd be arrested if I went back to that because there's an order saying I am by law prohibited from going back. How can that be somebody's domicile? Other than this statement in Grange, which was probably dicta.
Well, you'd have to go through the factors and apply all the facts in that case. So
How about if the sister's house had burned down? He's gone for 17 years. They've moved. How about somebody who goes to prison?
That's a really good question.
Yeah.
Okay.
I'm out of prison and I have one of these poor souls that have nowhere to go. No family will take me in. I'm 3 days out and I get into a car crash. What is my domicile back prison?
No.
Hopefully I don't have an intent to go back there,
That's exactly.
but
why.
I got mail there. I have clothes there.
Right.
But yeah, is that my domicile then?
No, once you leave prison, you never plan on, you don't have the intent to go back. It's not where you want to
Well,
be.
Right. So who's that ex-convict's, what's his domicile?
Probably whoever they list with their parole officer, which Mr. Copeland in this matter listed his sister's address. He lived with his, I mean, it's undisputed, he lived with his sister at one time. And
So the cases that you cited regarding domicile, they were cases where domicile is really necessary, like, you know, the case of custody or the SORA Act. Do you have any no-fault cases that you can point me to? Because I looked and couldn't find any that were like, you know, kind of parallel.
I mean, I rely on everything I put in the brief, like the Farm Bureau versus Progressive one, which was factually similar. Plaintiff tried to distinguish it, which I'll get to in just a moment. In that one, the claimant lived with his grandparents, moved out with the grandparents, was homeless and transient, just like Mr. Copeland in this manner, for many, many years. But this court found that because he never established a new domicile, his domicile remained with his grandparents.
So if so going back to Judge Kelly's example, if I'm in prison, 10-year stretch, I'm still domiciled for all purposes under the law, still at my parents' house or my ex-wife's or girlfriend's or wherever I was before I went in prison.
Well, you'd have to go through all the Workman Dairyland factors, all 9 of them to determine that. But the main one is you don't have an intent to remain or return to that jail.
Okay, so,
But what if you have no intent to remain at the sister's house or to go there?
yeah,
but
I mean,
that's
you
not
have one factor. They listed it as an address.
right. But that's not the only factor in this case. He gave this address to his parole officer, which he had to change.
But these are all addresses.
Mailing, just for mailing purposes.
like
He
if you had
explained
given a
it.
PO box,
He had medical devices delivered to this address for which they
and a PO
they billed
box,
us. His state ID had this address.
but you get these ones that have a general residential address that are just PO boxes.
He informed the MAIPF on 2 separate applications for benefits that he lived there at the time of the accident. And on the second application for benefits, he stated that his sister lived there as well.
Was there an opportunity for him to put that he was unhoused? Like, I mean, typically when people ask you where you live on an application, it's because they're going to mail you something, right? And all of these things have very tight timelines where you have to respond pretty much immediately or you lose benefits. So if he wants to get mail back and be able to get these benefits, doesn't he have to write down an address where he knows that he's going to be able to retrieve the mail?
Yeah, I agree. I mean, that's what he said in his affidavit. He said this is the only, quote, stable and consistent address that he has. This is the one that he's used for the entire time.
So if that's the only fact you have, that's true, and that's the fact you have. If that's the fact, is that enough in and of itself to establish domicile?
Yes, because he never reestablished a different domicile.
Don't we have to
after
go
that
through
one.
all the other factors?
Well, absolutely, we can go through them. I mean, I laid them on my brief, but
We don't have to go through them, but I'm saying, don't we have to go through other facts? You just said it was enough if that was, mailing address and a permanent residency, that's all he needs to establish domicile is what you said. And my question to that was, don't we have to still look at all the other factors and weigh all the other factors?
I mean,
Absolutely.
so if just because you can't say the sister's address, you just because you can't say, okay, this is the domicile, doesn't mean that because you have one factor on the sister's address that you win. Do you see what I'm saying? Like, despite the fact that you can't nail down any other domicile, you still have to show that the sister's house is the domicile.
Correct.
And that's not what I got from your briefing. I got kind of like, well, we don't have domicile anywhere else, so it's this one because we have one factor.
And you have
Based
to
upon that statement in Grange.
Yeah,
that
because you
everybody-
have to have it.
Yeah, I mean, I understand your argument. I'm just saying that I think I don't know that we're bound by that particular statement in Grange because it leads to absurd results and it might even be dicta.
Well, again, everybody has a domicile. Even homeless people, even transient people have a domicile somewhere under the law in Michigan, set by the Michigan Supreme Court. And it doesn't change until you get a new domicile.
And
Going
that's,
through-
that you're basing that, your statement that it's under Michigan law is based entirely on Grange.
On the Grange case, on the Farm Bureau versus Progressive matter, plaintiff cites a case.
But those all derive from Grange, right?
Yes,
So it's all traced back to Grange and this one statement that Judge Kelly very articulately and soundly says perhaps it's dicta and perhaps is leads to absurd results.
well, the Grange case has been out since 2013, so there's been a lot of case law relying on that specific case, even by this court in previous cases.
But the fly in your ointment is that affidavit, isn't it?
No.
He certainly seems to establish some other domiciles.
So during his testimony, he said the only address he could remember was some address in Wayne, Michigan, the city of Wayne. If you look at the addresses on his affidavit, which isn't admissible, which I'll get to in a second, he lists 4 different addresses, never even talks about that one. There's a difference between where I resided at and where I'm domiciled at. I could have multiple houses. I could have a house here and a house down in Florida. I'm domiciled in Michigan, but when I go to Florida, stay there for the winter because maybe I'm a snowbird, excuse me. I'm not domiciled in Florida. I'm still
If you
domiciled in
apply to
Michigan.
all Dairyland, all those factors, okay, 17 years before that was the last time he briefly rested his head at his sister's. 17 years.
Doesn't even have a toothbrush there.
Well, I don't know if it's really 17 years. He testified it was
Oh.
10 to 12 years.
Right.
But
Now,
still-
he's been in
Still.
prison. He's stayed with other people for 3 or 4 months. That he stayed, according to the affidavit. I mean,
Right.
it
Stayed
just
with his
seems-
mother for years.
Right. So, I mean, again, I think Judge Maldonado asked the question, and, if it is true that everybody has to have a domicile, the question is, where was his domicile? But
Most recent one.
it's not with the sister. So it has to be somewhere else, but you could establish by those factors in Dairyland that it wasn't the sister. So, that's up to you to find out where else it would be, but
He provided us no other information. He told the MEIPF this was where he was living at the time. I understand, so he could get mail and all that stuff. But if you go through all the facts of this matter, he received mail there, his ID, the police report said he was there. He registered it with his parole officer where he had to check in 2 times or every other week with that.
All mail, we
That's
know
all
those
mail.
lists and it's all mail, but let me ask you a question.
It's
Setting aside the admissibility of the affidavit, whether or not that's admissible or not.
Right.
Do you dispute or say that there's an issue of fact regarding all the things that Mr. Fortner ticked off and said, look, here are all the things to establish that his sister's wasn't the domicile?
I do. I mean, he talks about an application for benefits where his sister filled out an application for benefits where they ask for who lives in the house. They don't say who's domiciled. at the
So there's
house. She's an attorney. she knows
So
the
there's
difference.
disputes about that.
Absolutely.
Okay, so isn't that an issue of fact?
Well, if he would have put it in his brief and argued that in the lower court or in his appellate brief, it could have been, but this is the first time I'm ever hearing about that. The affidavit, we filed our MSD, he filed a response, I filed my reply, he files a supplemental response to his MSD and attaches this affidavit, which is contrary to his prior deposition testimony. During his deposition, he said he was homeless and transient for this period of time. Then he all of a sudden submits an affidavit saying, oh, well, during that time, I actually lived at these 4 addresses.
He said he didn't remember. And if he had a chance to go back and take a look at mail that he had or cards or a calendar or date book or just, maybe his electronic, footprints, he was able to put together where he was at. But, I don't think that's an unreasonable, that's not the same. Saying I don't remember is not the same as saying none.
But when you testify and you say I lived in Wayne, Michigan, and you submit an affidavit and you don't even list the Wayne, Michigan address on there. He says during the time I moved out of my sister, I lived at these addresses. Testified he lived in Wayne, Michigan, affidavit, it's nowhere listed on there.
But
Clearly that's contrary.
Yeah, you also said though, when he applied, he said he resided with his sister. He listed that address as where he resided, right?
Right.
But that isn't what it asks. It says, what's your current address? Which is essentially, where do you get your mail?
Correct. And if you look at the question directly underneath that, it says, where was your address at the time of the motor vehicle accident? Or I'm paraphrasing.
Yeah.
And
It
he has the
says
same
injured
address.
person's address at the time of the accident. Again, where do you get mail? So that's like, where did you get mail at the time of the accident? Where are you getting mail now? I mean, that's nobody's, the average person reading this isn't saying, well, where's my domicile versus my residence at the time of the accident? I mean, any average person reading this is saying, okay, where am I going to get a response from these guys?
I understand. When he submitted the second application for benefits on July 26th of 21, at that time, he was represented by an attorney. If he had questions, he could have asked his attorney.
But again,
The
that's
plaintiff-
listing an address. Tell me the other factors. You say there's 9 of them that establish or support the proposition that his domicile is at his sister's. We have the address, and that's clear. I mean, police report, medical bills, everything else. So
Right.
that's one.
He had
One
medical,
of, was
he
8
had,
or 9
he had medical devices delivered to that address, so he had to pick them up
from this accident.
from 46700 Judd Road, Belleville, Michigan. Everybody confirmed they lived there at one time. He testified as the last address he could ever recall living at. It's the only address he used for the last 15, 17 years, however long he's been homeless and
Again,
transient.
let's focus on something other than the address. Did he sleep there? Did he eat there?
No, but you don't
Keep
have,
clothes there?
you don't have to reside at an address or a location to be domiciled at that location.
Right. So you look at these other factors
Right.
that are laid out in those cases. There's 8 or 9 of them.
Right.
And it's the totality of it all. So
Correct.
let's go through those other 7 or 8 factors,
All right.
other than the address,
So,
that support the idea that he was domiciled there.
all right. One last thing I wanted, before we jump into this, one last thing I want to mention before it slips my mind is plaintiff was aware of auto owners. On September 2nd of 21, the MAIPF sent a letter to him saying, hey, we're denying this claim because there's higher priority insurance at this address with your sister. That was in September. He didn't file the lawsuit till December, 3 months later. So plaintiff knew about auto owners and just never brought them in. The original case was dismissed. The original case was refiled because we were running out of time to get his deposition because he's in prison. Refiled it, still didn't bring in auto owners. He knew about auto owners. That's why the claim was denied, because there's higher priority insurance with the resident relative under section 3114.1. But the factors, sorry.
I did the same thing myself. That's funny.
The subjective or declared intent of the person remaining either permanently or for an indefinite or length of time in a place he contends is his domicile or household. Here, he used this address for the last 15 years. He gets mail there. He had the equipment delivered there. He said in his affidavit, which I believe is not admissible because of the whole contrary issue, but he said it's the only stable and consistent address that he has. Second, the formality or informality of the relationship between the persons and the members of the household. Well, it's his sister and brother-in-law, so clearly it's a pretty formal relationship between the two. Third, whether the place where the person lives is in the house within the same curtilage or upon the same premises. He didn't live there, so that one goes that it wasn't a domicile. Where am I? Apologize. The existence of another place of lodging by a person alleging residence or domicile in the same household. He didn't have any other place to go, not until he got the affidavit. Again, I don't think you can be domiciled in prison. You have no intent to remain there or to return there once you're released.
High recidivism rate.
Possibly, but you don't intend to go back. The person's mailing address, we've covered that. He used it for everything. Whether the person maintains possessions in the insured's home, well, he didn't maintain them, but he had things delivered there, like these medical devices that he got for treatment after the accident. Whether the insured's address appears on a driver's license or other documentations. His state ID has that address. He registered that address with his parole officer. Whether he has a bedroom maintained at that house, he didn't. Whether the person is dependent upon the insured for financial support or the assistant, it's unknown, but likely he didn't. He was homeless and transient. He wasn't relying on his sister for any financial help. But if you look at those and you weigh them, there's not one that outweighs all the others. It's supposed to be taken as a totality. They lead that he was domiciled at this home.
Or
And,
not.
and since that time, he just never reestablished a different domicile.
I think we understand your argument.
Yes.
Is there anything else you wanted to bring to our attention?
Just plaintiff mentions in his brief that should Mr. Copeland found not to be domiciled there, that we're responsible for the benefits in this matter. It's not entirely true because there's a question of whether or not he provided the MAIPF with false information, which would be barred under section 3173A sub 4. But plaintiff knew of auto owners from the very beginning of this case and chose not to bring them in. We cite that in our brief under the facts section, page 10, paragraph 2, the last sentence. We tell them that the reason this got denied is because there's higher priority insurance with auto owners. And plaintiff has the duty under the Griffin versus Trumbull matter to do a due diligent investigation, put all applicable insurers on timely notice. And in this case, he didn't. So we find that the trial court didn't err. They balanced the factors, went through. Judge Edward Joseph continually asked the plaintiff during the hearing, what other address could be his domicile? And there just simply wasn't one. The trial court didn't err in this matter. And we're asking that this court affirm the trial court's ruling.
All right, thank you very much.
Unless you all have some different questions for me.
You have any questions?
No, I don't.
No, thank you.
Do you need a break? Yeah, okay. We're gonna take about 10 to 15-minute break and we will resume the case call. All right.
Second, I forgot my glasses and milk.
Just one moment, please. All right, we're gonna call number 26 now, 374-512, Brewer versus Adams.
Good afternoon, Your Honors. Catherine Ross on behalf of Defendant Appellant Chippewa Valley Schools. I'd like to reserve 5 minutes for rebuttal. Hopefully won't need the full time. So we're here today on a case that stems from an automobile accident that occurred on May 19, 2023. However, this is a case involving governmental immunity, specifically the motor vehicle exception to immunity under Section 1405. Now, this requires plaintiff to establish 5 different elements in order for the motor vehicle exception to apply and open up liability to the school district. The first 2 elements, that the driver, Paul Adams, was an employee of the district and that the district owned the school bus, are not in dispute. The dispute comes in with the last 3 elements: whether there was negligent operation of the school bus, whether plaintiff suffered a bodily injury, and whether said bodily injury resulted from the alleged negligent operation. So I believe everything was fairly well briefed by both parties in this matter. So I'm just going to kind of hit the high points unless the court has questions.
Any questions to start out? All right.
No.
Okay. So first, with regard to negligent operation. In this case, there is no evidence that Paul Adams was negligent in his operation of the school bus, other than the happening of the accident itself, which is not sufficient to meet that threshold.
Other than he didn't stop before he turned.
He did stop. Now, I know where that's coming from. So the video is a short clip. Unfortunately, it is not the full route that he had been operating that day. So the video starts when he's initiating his turn. However, at deposition, Plaintiff himself even testified that he saw the bus at a complete stop in the center turn lane.
Yeah, but we have the video of the accident. We watched it and the bus driver didn't stop. He got waved in and that's super dangerous, right? Like I hate it when people do that because they're they're sitting there waiting for you, but you can't see who's coming in. It's exactly what happened. He's not going fast. He's going, I don't know, 4 or 5 miles an hour or something, but he doesn't stop. We can see it for ourselves.
And I would say, again, that is part because it is where the video was clipped from for preservation purposes when the school district saved the video. That was something that was not raised until the summary disposition stage by plaintiff's counsel when the video was produced early on. But that is unfortunately, so the buses and everything, it's like any security footage, it only saves for a certain amount of time. They get the information to preserve it. They preserved. Unfortunately, where they clipped it from was the start of the turn. Mr. Adams testified he came to a stop. He'd been waiting there for traffic to clear. Plaintiff testified he came to a stop, or he saw the bus stopped. I agree with you, the waving on. I hate when people do that. It is the scariest thing. Mr. Adams did testify to that point also, though, that he is above everyone in the bus. He had a very clear view of the right lane.
He stopped in the turn lane?
In the middle turn lane.
He stopped in the middle turn
Yes.
lane before turning.
He testified that he stopped with his blinker on, waited 1 to 2 minutes for traffic to clear. A large gap formed. At that point, he inched forward, which is where the video is starting, and he starts initiating his turn. That's when the person's there waving, which we can all agree is
Who had
unsafe.
the right of way?
So that's another point. Under Section 649A of the Motor Vehicle Code, an individual turning left at an intersection that is not turning left at not an intersection, essentially, such as this in a parking lot, they're to yield the right of way to any vehicles oncoming that constitute an immediate hazard.
That
Now
might
I
have
have
been a
two,
Freudian slip because he originally said at an intersection, and this isn't an intersection.
correct.
Isn't
It's
statute dealing with intersections?
649A.
Well, whatever it is.
I believe it might be an unregulated intersection. Location other than an intersection. 649A deals with other than an intersection. So he's turning into the school parking lot. He's to yield the right of way to oncoming vehicles that constitute an immediate hazard. Now, 2 points to that. The evidence presented demonstrates the plaintiff was speeding in excess of the posted speed limit prior to this accident. That has not been refuted. Plaintiff himself testified he did not know how fast he was going, and there's been no other expert testimony or challenge to the accident reconstruction report that was submitted by Gary McDonald. So he has now forfeited his right of way under Section 649, subsection 7.
But didn't you just testify that your client, because he was in a bus, could see further away? Were there any obstructions such that he couldn't see, based on the turn? And if that guy, as you say, was speeding, couldn't see 50 yards down or 100 yards, see this car approaching?
So that goes to my second point regarding Judge Kelly's question on the right of way. It has to do with whether he's an immediate hazard. Now, Paul Adams testified that yes, he had a viewpoint, he could see above, he could see that the right lane at that time was clear. He never saw plaintiff's vehicle. Plaintiff himself testified he did not know where he had come from. He didn't know when he got into the right lane. He didn't know how long he'd been in the right lane. There's no idea. We don't know if this is a dart out situation, an acceleration from 21 Mile Road. It's unclear. But at the time Mr. Adams initiated his turn, there were no vehicles in the right lane. He thought it was clear. He slowly proceeded, as Your Honor stated, maybe 4 or 5 miles an hour into that turn. So at that point, plaintiff's vehicle was not perceived, and there's no evidence indicating it would constitute an immediate hazard under the statute. So there was no right of way to be yielded to.
Do you have
the
any
plaintiff.
case law that supports your conclusion under similar circumstances that support that that's no immediate hazard as that term is defined?
So we do cite two. It is an unpublished case with very similar facts in this. It's the Estate of Dangler case that is in our brief. It is docket number 291414 of this court. And in that case, it's a situation where a school bus is turning left into a school parking lot. There's a backup because of a traffic light. A boom truck, which makes it slightly different in that it's a big vehicle, waves the bus through. The bus proceeds slowly, ensuring doesn't see anyone on the other side of the boom truck. A motorcycle is coming by in that right turn lane to bypass traffic that is stopped for the light and collides into the side of the bus. In that case, the court found that there was no negligence on the part of the driver and that the motorcycle was not an immediate hazard in that situation. So factually analogous, while unpublished, is persuasive.
Does that, I could be wrong, but is there a distinction in that case because the motorcycle argued that it was in the wrong lane for emergency purposes? Maybe I'm thinking of a different case.
Is that the motorcycle was
Yeah.
had an emergency?
Yeah.
I don't recall there any being argument about the motorcycle having an emergency. That I believe it was that they had been trying to bypass the stop traffic because they were intending to turn right at the traffic light farther up on the other side of the school.
But in that case, isn't the fact that the motorcycle bypassed a bunch of traffic, that the boom truck had stopped? And instead of staying in that lane, they went on what I'd say the shoulder, and it was a motorcycle, so it was able to do that because it wanted to get into the right turn lane. So doesn't that make it factually different than this case?
Well, it was a travel lane at that point. But I do not believe it makes it different because, again, in this case, we also have someone who, it's all speculation as to how he got into that lane, but it's someone who is traveling in excess of the posted speed limit and also too fast for
Is it
conditions.
speculation or is it an issue of fact?
Regarding where he came from,
Yeah. Does that matter? Because if it matters, then isn't it an issue of fact that the jury gets to decide where he came from?
no, where he came from is irrelevant. It goes more to plaintiff's arguments regarding that he was there to be seen, when all the testimony and evidence demonstrates that he wasn't there to be seen, and his own testimony cannot create a question of fact that he was there to be seen because he didn't know where he was coming from and he didn't know the vehicle, the speed of
He
his
wasn't there to be
vehicle.
seen. I mean, they just appear out of thin air.
Because of his speeding, he created the hazard in that he
He might have been
Yeah,
speeding.
he
And,
was.
and if you're right on that issue, I think it applies to intersections, which this isn't. But that's a separate question from he wasn't there to be seen.
Well, at the
He's driving
time,
down the lane. I don't.
Right, like,
what am
yeah,
I
I mean,
missing?
unless you're telling me he's like the bus driver, who you admit is sitting above, which would give him a clear line of vision for called 100 yards. And this guy, his testimony is because he's speeding, I couldn't see him being there within 2 seconds.
he did not, yeah, he testified he did not see it. The right lane was clear at the time when he initiated his turn.
That
Plaintiff,
sounds like negligence to me, because you have to make sure it is clear.
and to him it was, he did not, there were no
How did-
vehicles in the right lane when he initiated his turn. And so he is supposed
Well,
to,
wait a minute. He didn't see anybody in the lane. Doesn't mean there was nobody there, because obviously there was somebody there. Otherwise, we wouldn't have had an accident.
well, and the accident though, just because it happened, isn't sufficient to establish negligence on the part of the driver.
Separate question. I mean, this business that the guy just appeared out of thin air is, kind of crazy. You got some other arguments that could go either way, but that one's just not landing.
Okay, I apologize, Your Honors. It's more that he himself created the hazard under the statute, which then created the accident by going in excess of the speed limit, especially in light of the conditions when he admitted traffic was stopped and the right lane is now going to be merging into the left lane just past the school. Essentially, he's now creating this hazard by speeding up to try and potentially bypass traffic. And the bus, when he initiated his turn, he said he did not see anyone in the right lane. He proceeded his turn, he started into the driveway, and then the accident happened.
So let me just clarify your argument though, just for on appeal. You concede everything but causation? Or what else?
We also are stating though that there's no evidence of breach of any duty by the driver.
But there is a duty.
There's, yes, there is a duty owed with regard to safe operation of a vehicle when driving as a reasonable, prudent person with due care and caution, which he did. The evidence demonstrates that he did do that. He looked, he initiated his turn slowly, and he proceeded through his turn. Had there been a vehicle, he would not have turned. But that wasn't there. Plaintiff
Here
then,
we go again. Yeah. Okay.
had he seen a vehicle, he would not have initiated his turn. So the record evidence in this case demonstrates that he did not breach any duty, nor was he the cause of the subject accident.
Except the video that shows you didn't stop.
Again, the video unfortunately does not start.
Yeah, that's unfortunate,
Yeah,
but that's the evidence I have and I trust my own eyes.
right. I just would argue that we have testimony from both plaintiff and the driver that the bus did come to a full and complete stop. So,
Eyewitnesses are notoriously terrible. That's why it's so great when we have video.
I would agree, except for the fact that plaintiff also agreed that the bus had come to a stop. So I believe that further corroborates the driver's testimony that he did come to a stop. So,
What point do you say there's a factual question on an issue like that?
pardon?
At what point is there, a factual question? And looking at it in a light most favorable to the non-moving party?
When there is other evidence presented to refute the evidence presented
Like a
by
video of them
defendant.
not stopping and.
Even with that, again, there's still this evidence that he was speeding, which was then the cause of the accident.
That doesn't nullify, I mean, our Supreme Court's made it pretty clear that that doesn't nullify the duty owed to other motorists. You can't just, as I think the Supreme Court said, you just can't blindly put your head down and plow through.
And he didn't do that though. He still was seen on the video
Well, we don't know.
looking forward and also looking southbound on Romeo Plank Road and to see whether or not the lane and traffic was clear to proceed.
How fast did your guy say he was going?
I don't believe he fully testified. It was 4 to 5, maybe even 6. Buses are very hard to start moving.
No, I'm talking
yeah.
about the plaintiff.
Oh, the plaintiff?
How fast, you say he was speeding. How much over the speed limit does your experts say?
He doesn't put a definitive amount number on it, given the information available, but given the amount of damage, the time that you can hear braking on the video, and the location and of the accident and the photographs that are taken at the scene with skid marks and everything, it's well in excess of 50 miles an hour is the best he could come up with at that point.
But the plaintiff didn't concede that he was speeding. It's just the accident reconstruction provided evidence that there was speeding. Is that correct?
Well, plaintiff, when asked what his speed was, his response was, I don't know. He didn't know what his speed was
Your
at the
expert
time.
doesn't know either.
No, but he does know his opinion based on all the evidence presented was that it was in excess of the posted 50-mile-an-hour speed limit.
Okay. Thank you. We understand.
I mean,
Okay.
if it's 51, given the length of the bus and how slow a bus turns, I mean, he still could have been turning. I mean, the accident still could have happened even without the guy, even though he was speeding, right?
And with the amount of damage, it's Mr. McDonald's opinion, it's more than that. This is a significant damage accident, and based on the speed, it had to be well over the 50-mile-an-hour speed limit.
Seems like a pretty loose opinion. I mean, normally they do calculations. They can tell you just how fast it goes. Apparently he's able to just,
Part of the problem was also that plaintiff's vehicle was no longer available at this point. It had been,
but that is a problem, isn't it?
yes,
Yeah.
plaintiff's vehicle
So your
was,
guy looks at a couple photos and some skid marks and gives
in the
an
video.
approximation
Mhm.
of, I don't know how fast he was going, but it was over 50.
And yet there's still no evidence to refute that that's been presented by plaintiff in this case, whether in the lower court or on appeal. He didn't know how fast he was going. They never produced an accident reconstruction expert even to challenge Gary McDonald's opinions. So there's nothing to refute it.
Okay.
So based on that, it's our position, there's no evidence of negligence. Now, moving on to the second element that is in dispute is whether or not plaintiff suffered a bodily injury. Now, this one, the court has made clear that under 1405, you have to have physical injury to the body that also satisfies the requirements of 3135, which is a threshold injury under the No Fault Act. They go together. Here, the medical records demonstrate that it's at most soft tissue injuries. The findings on examination were subjective in nature. There's no objective findings to support a physical basis for them, nor have any of the MRI studies been attributed to a traumatic injury or the subject accident. So it's our position that he can't establish the bodily injury prong. Now, the causation part, causal relation part of that, the attributing to the accident, goes into the third element that's in dispute, which is the resulting from standard. Now, in Robinson, the court held that whether an injury results from the alleged negligent operation of the vehicle requires more than a but-for proximate cause analysis. It has to be a direct consequence of the accident. Now, this court, following Robinson, in the context of a case like this one, where someone's claiming various injuries as a result of an accident where there is physical contact between the vehicles, that's not in dispute like it was in Robinson. The courts have found that that requires there to be testimony, something in the record from the doctors indicating that the injury is a direct consequence of the accident. It's not from a longstanding degenerative condition or a different injury that may have occurred post-accident, something like that. In this case, we don't have that. On briefing, plaintiff doesn't cite any record evidence from any of his treatment providers directly relating his claimed injuries to the happening of this accident.
So what was the tear to his left shoulder from?
He worked a labor job, could be from that, but again, they don't say that. And his left shoulder resolved and was not being claimed after this accident. But no doctor full-blown attributes it and says this is because of this accident, which is what is required. It's a higher standard than a typical but-for proximate cause standard. And because they don't cite to anything with that, that standard has not been satisfied. So for those reasons.
Was he working before the accident?
Yes, he was working as I can't remember the exact title of it, but it's basically an Amazon fulfiller.
And wasn't he disabled by his doctors because of the shoulder tear and then given a huge list of things he could no longer do after seeing the doctors after the accident?
He was, however, as noted by the court in the SETA case, the opinions, in order to satisfy the resulting from prong, you need to have a thorough review of the records. So he never saw any pre-accident records. It's even unclear if they even saw the emergency room records, anything other than his subjective reports. So that wouldn't satisfy the requirements for this resulting from prong to make this a direct consequence of the accident for purposes of 1405, which falls in line with the court's regularly held position that exceptions are to be narrowly construed in favor of immunity, which is why they impose more elements than a typical auto negligence serious impairment case, as well as a higher standard.
That's on the negligence. I don't know that the injuries fall into that category, do they?
With regard to when you're talking about the resulting from prong, yes. So even if he does satisfy, say, a serious impairment under the No Fault Act, that's still not sufficient to then get over the hurdle of the resulting from prong, where you need to have testimony or record evidence that the claimed injury is a direct consequence of the accident itself, instead of prior history, maybe there's a subsequent accident, fall, something like that. And we don't have that in this situation. So for those reasons, we're asking that the court reverse the lower court's denial of summary disposition.
Okay, so you want to save those 8 minutes?
Yes, please.
All right.
Thank you.
Uh, Good afternoon. May it please the court, John Nagis on behalf of plaintiff appellee Anton Brewer. I think the court's pretty well aware of the facts, so I'm going to just basically jump right into addressing some of the points that were just raised. First, I think whether or not the bus was at a complete stop, even if it was, 2 minutes before the video and it cuts to the video where he's accelerating to turn, even if that's true, I think it's a red herring. I don't think it matters if he was ever at a complete stop before he caused the crash or not. He had a duty to yield to oncoming traffic in the other 2 lanes.
Well, she's arguing he didn't because the other person was speeding. He responds?
Yeah, so a couple things. One is I tend to agree. I don't think that the carve out for speeding is part of the non-intersection turn statute. But even outside of that, there's general duties owed by all drivers, assure clear distance ahead, basically just don't cause crashes that you could avoid. And also, I don't hear any argument that my client's alleged speeding was an intervening and superseding cause.
Well, wasn't also he not following the rules about having both your hands?
Yeah, he lifted his hand off to wave at the person. Whether or not that could have prevented the accident, I don't know.
But isn't the argument is the right of way. And if by speeding in under these circumstances, your client forfeited the right of way, then I mean, it looks like it's game over.
I tend to disagree with you on that because basically my theory of that would be, sure, let's say that my client forfeited the right of way. I think there's a question of fact on that, and I think that that's not part of the statute. But let's hypothetically say he did forfeit the right of way. I still think you can say, hey, bus driver, you still should have seen and perceived this person. Yes, was my client also negligent in this fact pattern? Absolutely, my client was also negligent, but it comes down to a comparative fault issue because just violating the right of way is not enough to be completely unforeseeable that someone would be speeding, driving down the road is a very foreseeable thing, does not break the causal chain to his negligence of hitting my client. So yeah, there's a right of way question, but I don't think you need to get there. I think you can just say it's a question of fact and also it's a question of comparative negligence.
You say so.
So, and just circling back to is I don't, again, even on that fact pattern, I don't think whether or not the bus was moving immediately before turning is relevant to that, even that fact pattern. It's the bus either had a duty to wait for traffic to clear or not. Them being stopped is not a relevant fact, no matter what. But again, that's a question of fact too, as the court already addressed. On that same note, the video does have the miles per hour on it. It's clear in the video. He was moving the whole time, at least as far in the video clip. I think that creates a question of fact, even despite my client's testimony.
Do you recall how fast he was going?
I think he peaked at like 23, like he was in the 20s, then he was slowed down as he was coming into the turn. I want to say like between 5 and 7 miles an hour, something like that. But
I'll take another look.
Yeah.
I missed that.
it's bottom right corner, I believe, of the
Thank you.
video.
And honestly, it's been a minute, so I'll go back and take another look.
So then one point of to distinguish that unpublished case that you were talking about in regards to the motorcycle with the boom truck is in that case, one, you had the motorcycle operating illegally, and it was seemingly undisputed that the motorcycle was operating illegally. It's a question of disputed fact still in this case, in my opinion, at least, whether or not my client was doing anything illegal. And even if he was speeding, whether or not that would be enough to merit a causal chain break. And if we go on a causation analysis.
Just expand for me, just so I understand. Motorcycle operating illegally was based on a what?
I don't remember the details of that unpublished case, but I'm pretty sure that he was coming up the right-hand side and either went too soon to the right turn lane and like crossed a bit of the shoulder to get there.
Yeah,
But
that was my understanding.
it's been a minute
but
since I
that's
looked
why
at
was
that specific case.
Okay, thanks.
And also, and basically in that case, my recollection of it is that it was a reasonable and prudent bus driver would not have expected a motorcycle in that spot behind this big truck. Whereas in this case, there's no testimony, anything obscured his vision. It was a 2-lane road coming the other way. No testimony besides from the expert witness, which may or may not even have been admissible because there is no science at least as far as I can see underpinning it. And I would think on a Doppert hearing, it probably, there's at least a decent chance it gets tossed. Because there's like, he doesn't even tell you, he just says, oh, probably more than 50. To me, that's not, there's no science there. It's not a reliable conclusion. But distinguishing that case, a reasonable improvement bus driver would not have seen, or there's no expectation they would have seen this motorcycle coming out of nowhere. Whereas this case, yeah, a reasonable improvement bus driver should have seen my client's vehicle. The other thing I would say is on the speed issue. My client testified that he was driving with the flow of traffic immediately prior to this. He could not recall specifically what his speed was, but I don't think there's any evidence whatsoever that he was driving at some sort of reckless speed or reckless rate or weaving in and out or anything like that. There's nothing in the record to demonstrate that.
Well, I mean, you got their expert that says
Maybe
whatever the speed was, it was
over the speed limit, over the 50-mile-an-hour speed limits. All their expert says. He doesn't say that he swerved out from behind a different car and came out of nowhere.
Is what you're suggesting is that because he was with the other flow of traffic or traveling at the rate and the speed of the other flow of traffic, that would have informed the bus driver's duty or knowledge of whether he was acting reasonable under the circumstances, given the relative flow of traffic.
Yeah, exactly right. And also, yeah. And the only thing I would add to that is it would also, to some extent, give the bus driver additional information about how much room he had. When he's seeing all these cars coming up from the distance, passing at a certain speed, a certain rate, and my client says, I was going same as everyone else, he should have known he didn't have space to make that turn. Regardless of if my client was speeding or not, he should have seen it, known I don't have space, and not made the turn. Then the last point I'll make, and then I can just answer any questions, is this is defendant's burden. This is their motion for summary disposition. It's their burden of proof to this court. They say things like, you know, I haven't, or that my client didn't prove that his injuries were directly caused by this crash. It's their burden to bring an expert that says, oh no, this was degenerative. They have provided zero evidence that any of the injuries at issue in this case are degenerative in nature. And that all of the testimony is, yeah, I was fine before the crash. I was playing basketball. I was lifting weights. I was going out to Cedar Point. I was working at Amazon, throwing packages around all over the place. He didn't have any history of back, at least as far as they presented, no history of back injury, no history of shoulder, hip, whatever. How is it possible that that my client would need to produce an affidavit from his treating physician who was not at the crash saying that this crash clearly is what caused it? And furthermore, even if it was the aggravation of a pre-existing condition, it's well settled law. I think it's Wilkinson versus Lee, that pre-existing conditions, any aggravation of them is still a bodily injury under both.
Well, but she raised it, and the burden shifts to you to rebut it, right?
But there's no evidence. They can argue, hey, we don't think that his injuries were caused by this crash. What evidence did they put forward?
What evidence would you point to medically?
Medically? So,
I mean, is there an application for benefits? Doctors usually tick off that it's related, so that wage loss and all that, I mean, is that in there?
I believe it is. I can't answer that specifically, but what I would point to is one is his testimony about his pre versus post accident.
I'm talking about the medical linking.
Right. But then additionally, you have the ER records, which show that he shows up with contusions on his body. And whether or not, those are part of the serious impairment side of things is it's completely different than whether or not there was a bodily injury at the crash. We proved for the governmental immunity piece of this, there was bodily injury just from the ER record. Just look at the ER record. He shows up contusions, right shoulder, right hip. And then over time, it develops into more of a back injury once the adrenaline stops, once the pain medicine wears off.
And a doctor did disable him from work, right?
Nurse practitioner and chiropractor, but yes.
So I mean, there's
yeah. Oh yeah. And there's MRI records that, show all the spinal issues. There's tons of records of tenderness to palpation immediately after the crash. There's tons of multiple positive orthopedic tests. There's plenty of evidence that he was injured. And there's no other evidence of any other reason for the injury outside of this crash. There's no testimony that he got hurt at work. There's no testimony he fell. There's nothing that they presented The only reason for these injuries is this crash. And they didn't provide any other reason to believe that they weren't caused by the crash, or at least exacerbated by the crash.
Okay.
Any last questions? All right, appreciate it.
Just a few points for rebuttal. First, with regard to the flow of traffic, plaintiff testified there were no other vehicles in the right lane in front of him when he was traveling, and the traffic to the left lane was at a dead standstill, backed up. So he was not going with the flow of traffic as it existed around him. He was speeding in a right lane surrounded by traffic that was at a dead stop in an area that he admitted was busy because school was getting out. So he's now on notice that he needs to be traveling at a safer, more reasonable speed given the circumstances around him so that he can stop in an assured clear distance.
Why is that not comparative?
Because there's no other evidence to demonstrate that he wasn't traveling in a safe manner. All the evidence that has been submitted, and plaintiff hasn't submitted anything to the contrary, is that he was speeding in excess of conditions and that was the reason for this accident.
I don't want to blindside you. I want to give you a chance to respond. I was able to pull up the video and watch it. It is very clear the bus is going 26 miles an hour at the beginning of the video and continues right into that lane and turns and does not stop. And you can see the other traffic continuing at a speed on the other side through the other side of the window.
I don't have an answer for that he wasn't confronted with that at his deposition. I don't know what the explanation would be for that, other than he could have stopped farther back, accelerated forward because the bus needs some momentum to get going. He's seeing it. He's not seeing any other traffic coming, and he's turning. That's what I have to work with on this. I do know from other cases that the speed indication is not always exactly accurate in the moment. I cannot say for sure that's the case here.
So doesn't that come down to a fact issue for a jury to determine, to look at that evidence, look at your evidence and possibly your accident reconstructionist and weigh that and then do some sort of comparative analysis as suggested by Judge Kelly?
They could, except I would still argue here that plaintiff hasn't put forth sufficient evidence to rebut the presumption that he was negligent in causing the accident by traveling in excess of the speeds in violation of Michigan statute.
And your evidence that was produced is your expert's report,
which does have calculations in it, but yes.
Okay.
Other than the
And
most
his
important
own-
one, which is how fast it was going. And then secondly, I mean, a bus isn't like a Ferrari, okay? To get to 26 miles an hour, a bus doesn't do 0 to 26 in 3 seconds, does it? So obviously it
hope
would have
not.
taken him, maybe Mr. McDonald can be asked this question, how long it would take that bus to get from a stop at 0 to 26 miles an hour? I
Well,
suspect it's not a short amount of time.
Well, you even made that point when you were arguing
Yeah.
earlier. So, I mean, I think you understand that.
Yes, I do. And I, like I said, I don't have an answer for that. It was not something that was raised in Mr. Adams' deposition. He was not confronted with that, nor was it something challenged by plaintiff when we produced Mr. McDonald's report during discovery. So I don't have
But this
answer.
video was down below, right?
The video was down below. I believe the court, they were provided it.
So we can
Yes.
consider it.
Yes, the video
Okay.
can be considered. It was provided.
All right.
Going also though to the burden of proof that was raised, because this is an immunity case, the courts are clear that the burden to establish an exception to immunity is on plaintiff. And they have not put forth the evidence necessary to establish the motor vehicle exception applies in this case. With regard to the injury issue, we did produce the report of our IME doctor, Todd Francis, who reviewed all of the records provided and determined that the claimed injuries were degenerative in nature and not related to this accident. Plaintiff didn't produce anything.
How long was his examination of plaintiff?
I don't know how long he examined plaintiff for. But he did review all the records, imaging studies, and did a full examination of plaintiff. He may have even taken x-rays, I don't recall in this matter. But again, plaintiff's counsel hasn't produced anything to rebut that. or any testimony demonstrating or records that this was directly related to this accident. So unless there's any other questions.
No.
Thank you very
Thank
much.
you.
You're very passionate in your argument, and very prepared. I get it.
Yeah.
I don't agree with everything you said, but you did a really nice job.
You did a great job.
Thank you.
You, not so much. No, I'm just kidding.
No, you too. But you didn't have as long to argue, so.
We weren't,
You know,
we
you know,
weren't
I'm just
grilling
joking.
you.
You know, I'm just giving you a hard time.
Whenever we're mean, we give a compliment after.
Yes, that's a good. Cool. Last but not least.
Come on, let's call the next case, 27-370-964. Holman versus Farm Bureau General Insurance Company. Obviously, I'm sorry, we're all getting a little tired. It's the end of the day.
You guys are resting on your briefs, right?
Close, close. By the way, I like your tie.
Thank you, thank
you. There we go. May it please the court, my name is Rob Kamenek. I represent the plaintiff appellant.
Nice to see you, Mr. Kamenek.
Thank you. Nice to be here. It is late in the day, and so I will primarily rest on the brief, but I've got to make a few comments.
Okay.
Number one, it wasn't clear from the existing paperwork, unless the court went back to the previous opinions and the previous briefs about what happened to my client. So it's not salient in terms of the legal issues presented, but 11 years ago, there was a pretty catastrophic automobile accident.
Mhm.
And as you know, without insurance, and that was been the ruling all the way through here, that my client could not recover first party or third party pain and suffering. So assume you probably knew that, but
Yeah,
I
no,
thought-
we know that it's
Okay.
gone back and forth and that we looked at the preceding record.
All right. And from there, here's the best way I could put this. You've got this long process between the insurance agent and my client. And I think everybody is really trying to work in good faith, but there were certain things that happened here that I don't think were entirely fair to my client, but more importantly, I think they fall within the exception of hearts. One thing, and most of it's in the brief, one thing I really want to emphasize is the following. You know, this accident took place on February 5th of 2015, okay? And there was this process going on back and forth about trying to get insurance, whether there was a sufficient documentation for the insurance, whether there was notification of the cancellation and or the fact that there wouldn't be insurance. And one thing that jumped out at me in preparation was the following. On January 23rd, 2015, and that's about 2 weeks before the accident. The agent knew, and he admitted to knowing, that Farm Bureau was not going to write the policy. And that's in the depths, but if you need to look at the pages, it's page 110 of Mr. Heisman's deposition, appendix 154A. And Mr. Heisman admitted that at that time, he did not convey that information to my client, Mr. Holman. And that's found at page 111 of his deposition. Thereafter, the record shows that there was a meeting between my client and Mr. Heisman, the insurance agency, and they were considering other insurance. And quite frankly, as you know from the briefing,
Like
Mr.
$5,000 or $7,000.
It
for
was
the
pretty
other.
high.
Yeah, yeah.
I thank God mine's not that high, but it was pretty high. But the testimony from my client was, I still had an expectation because he had not been told that his insurance had been rejected. I still had an expectation that I was going to wait to see what was going to happen with my insurance. So he turned it down. And that testimony, I think, relates to February 3rd.
And which Hart's factor do you think that falls under? 4 of them, right?
Well, I think it falls under 2 because I think there was a misrepresentation. Now, we went through this a little bit with Judge McMillan, who's a fine judge. I just think she got this one wrong. If misrepresentation, in my view, would also include silent fraud. And would also include, as you have in the briefing, Michigan's the only state in the country, I think, that still has innocent misrepresentation. And so I think it would fall under that, the impression was given all the way through that we're going to wait and see what the insurance company does. We're going to see what quote underwriting does. And all of a sudden the agent finds out that indeed there's not going to be any coverage, doesn't tell the client. That's a problem. Okay. I think it's primarily under number one. I think that there's a case to be made too, that at that point in time, a little bit different because we're kind of intersecting concepts. When the agent said, okay, I'm going to help you out and try to find you insurance, that's element 4 under Hines or factor 4 or whatever you call it. And that's assuming a duty. And so we've got a little bit of both, so to speak. I hope I'm being somewhat articulate here, but I think it overlaps both of them. Now, there's a lot of other facts in this record. And again, it is late in the day. You've got the briefs. I know this panel. You've read it all. Presumably you have a pre-hearing report in front of you. But that's the one thing that really jumped out that's, I think, undeniable.
Sorry, you gonna?
No.
You rely in part on footnote 4 in Holman 2, right?
In part, correct.
In part. Tell me why that's not dicta, footnote 4.
Oh, it probably is dicta.
Okay, so you concede that?
I would concede that
Okay.
it's dicta because it wasn't necessary. Well, you know the rules of dicta. I don't have to go through them.
That's all right.
Okay.
Well,
I
I'll just
could.
take your concession.
But I'll tell you, again, this is a revelation I had this morning, and amazing what happens early in the morning. Too often I see, and it didn't really happen here, but with Judge McMillan, but we always get these rulings that say no reasonable jurors would find. And, and it beats up, my new career as a plaintiff's attorney. So kind of beats you up on that. Okay. But when you have, even in dicta, 3 Court of Appeals judges finding there's a question of fact, I don't know how you can get to the point that no reasonable jurors could find, because you just said that 3 Court of Appeals judges are not reasonable jurors. So I'm off on a tangent a little bit, but it's always hit me on that. And to the extent, and I can't read minds, anybody's going to go down that road vis-a-vis a question of fact, I would simply say that it's not, that's the value in that statement.
Yeah, let me ask you just another one. I want to make sure I understand the record correctly. What's your best evidence of the misrepresented the scope of the coverage? Is that the early communications in May and his discussion about, or not in May, that he may be able to get different coverage, or they may not extend the policy in early January?
If I understand the question correctly.
Sorry, I fumbled that a little bit.
You're fine. I'm sure it's me.
No, it's me.
The scope of the coverage,
Was
I don't
there any
think there was a debate.
misrepresentation of the scope of the potential?
Not my
coverage?
understanding. No, the
Okay.
duration was the issue. So when we go ahead and when we go ahead and look at the exceptions under Hart's, the agent misrepresents the nature or extent. This would be more the extent.
The extent.
answer your
Okay,
question.
that's exactly what I was
Okay,
getting
all
at.
right.
Thank you for better articulating it than I did.
Thank you. So the last point, when you have factual disputes that govern duty, it's got to go to the jury. And I don't think Judge McMillan's opinion went down that road. Maybe she didn't have to. I understand that. But for purposes of this analysis, the case law is pretty clear on that. And at that point in time, the judge can submit those factual questions to the jury and then decide duty. But I do think that there are factual disputes. There's no doubt, and we've explained it in graphic detail in the briefs, and I think all the briefs have. There's different and conflicting testimony between Mr. Heinzman and my client. There's no doubt about that. So unless
Does your client deny that Heinzman on January 7th told him that they were going to terminate coverage January 21st for missing prior proof?
I'm checking, Your Honor.
And I think this gets into, the notes of Heisman say that they may terminate coverage as opposed to that they will.
I'm not, as I sit here, I'm not positive what my client said. January 7th?
2015.
I got it.
in his second deposition, page 21, Holman denied being told Farm Bureau would not insure him or that he needed to look for other options. Page 21, Holman, there's two Holman deps, and I don't have the page, I don't have the appendix page, I'm sorry.
That's okay.
Okay, but it'd be page 21. I'd ask the court
But there's a
reverse.
fact question on that.
Absolutely. Ask the court to reverse and thank you.
Okay.
I don't think I'll need it, but I didn't reserve any time for rebuttal, but
You have plenty
I
of
have
time.
plenty of time.
Yeah, you're good.
Okay, thanks.
You're both arguing?
Yes, we're going to split our time.
Okay, so, but you're responsible for keeping track of that, okay? I mean, I'm gonna help you, but if I get lost in your argument and I'm not paying attention, can you please pay attention to your time?
Well, my phone is off, so
Oh. All right.
give me a kick, okay?
Careful what you ask for, right?
I
Oh,
want that back.
We aim,
Mr. Kamenek is a peaceful man.
we aim to please.
Yes. I represent the Heinzman defendants who were the captive agents of the Farm Bureau and who worked with the plaintiff to facilitate his application for the insurance policy with Farm Bureau.
Did you put your name on the record?
Ronald Letterman.
Thank you, Mr.
You're
Lett.
welcome. In spite of the complicated history and the voluminous history and the extensive briefing, I think that the controlling points here are very narrow. And I think that Judge McMillan recognized that with how she approached her ruling. The first controlling point that I want to emphasize, and that plaintiff really hasn't touched upon in either his brief or his presentation today, is that while the Supreme Court defined the precise issue for the trial court to resolve on remand as being whether or not the defendants owed a duty to notify the plaintiff of the quote unquote cancellation of the 30-day binder, the history of this case makes it clear that there was no quote unquote cancellation. There was a rescission of that 30-day policy as directed by the Court of Appeals in Holman number 1. The Court of Appeals further dictated that as a result of that rescission, the 30-day policy was void ab initio. So to comply with the Supreme Court's order, given the law of the case that existed and that still exists, the trial court would have had to resolve and find, in order to deny our motion, that there was in fact some kind of a duty by the captive agent to advise the plaintiff that his 30-day policy would not be quote unquote canceled, bless you,
Excuse me. Thank you.
but rescinded by the Court of Appeals and rendered void ab initio. The plaintiff's arguments have ignored this distinction, and yet I think it's a controlling distinction. And for the reasons that are set forth in our brief, there is no duty under the law. Certainly, it would be up to the Supreme Court to announce such a duty in the first instance if it believed that it exists, but it does not exist. Secondly, the plaintiff has proceeded under Hartz and has defined two exceptions to Hartz to create a duty to advise the plaintiff of the quote unquote cancellation of the 30-day policy. The first exception is whether or not the defendants expressly assumed a duty to do so. There is nothing in the record.
The first is the agent misrepresents the nature, extent of coverage offered or provided, isn't it?
Yes, I'm not skipping that.
Okay.
I could address that.
Oh, I thought you
first
said
if you
that's the
want.
first one. Okay, no, I beg your
I'm
pardon.
sorry. I
Late,
had it
late
in
in
my,
day two, I should just sip it.
I had that in my notes that I was going to address that secondly.
Beg your pardon.
Okay.
Go ahead.
But I can address it now because basically the assumption of the duty analysis is unsupported by any facts that we assumed a duty to notify the plaintiff that the 30-day policy was definitely about to expire on day 30 after we told the plaintiff 2 weeks earlier that if he didn't get his prior proof of insurance submitted, then his application quote unquote will be rejected or quote unquote may probably be rejected. Going to the misrepresentation element, again, what you have is 2 weeks before the expiration of the 30 days, you have Mr. Heinzman telling the plaintiff, you better get your proofs in of prior insurance coverage. Because if you don't, Farm Bureau will reject your application. Or in the alternative, in his notes, he wrote down May. Farm Bureau.
Does it matter if he said
I
May
don't
or-
think, no. Our decision, our contention is it does not matter
Because there's no duty, right?
because there was no misrepresentation, meaning there was no duty. And the reason why there was no misrepresentation is that either were true.
I'm sorry to take you off your course, but I'm just curious as this is the first case I've seen where you had somebody that was an intermediary. And I read the case law. You know, I understand that your client's duty is actually to the insurance company. And just for my own curiosity, not necessarily really, but what is presented to people when they're using your service to clarify that point?
To clarify
Yeah,
what
because
point?
as a consumer, I would assume that if I reach out to you and I'm like, hey, can you help me buy insurance? That you're working for me. And, you know, maybe you're getting some kind of, you know, stipend or something, I forget, some payment from the insurance companies, but.
Commission.
But thank you. It's late. Some commission, but do you guys provide people, just for my own understanding, I want the full clear picture.
The full clear picture is that this is the Heinzmans were a captive agent of Farm Bureau. I know that doesn't begin to answer your question, but when the captive agent facilitates the preparation of the application, he is doing so not as a counsel or a counselor to the insured. He is doing so as an order taker for the insurance carrier.
That's what the Supreme Court has said. I
Yes.
understand that. That wasn't my question.
Well, I'm sorry, I don't understand what it is that you are looking for with your question.
I just wanted to understand the whole process. Just to, you know, in a big picture view, when I'm looking at the case, I just wanted to understand how the consumer comes to the table. That's all.
The consumer may contact the insurance agent or an independent insurance agent that is working for the consumer may contact a captive agent such as us that is working for the insurance carrier. In this situation, there was a mutual friend that I believe made the reference or the initial communication and got us involved with the plaintiff.
You're right. It's a side issue. You can move on. I just wanted to understand.
Let me ask a different question, which is if your client knew plaintiff didn't have insurance in the prior 6 months, was aware of that, right? That's from the outset.
He didn't know for certain, which is why he told the plaintiff, you better get your proof of prior insurance into or to Farm Bureau within the next 2 weeks. Because the plaintiff said he had prior.
So why was there
insurance.
any equivocation on that point? Like, why is there a may or could? And I guess it seems to me as if perhaps your client was, you know, trying to assure him that there was a path through, you know?
No, he testified, Heinzman testified in his deposition that he used the language will, that Farm Bureau will reject the application. However, in his notes, he scribbled the word may. And that led to more extensive questioning. Well, did you tell the plaintiff, Mr. Holman, that Farm Bureau
Is it your,
will
is it,
or may?
maybe this is a question for Mr. Sangster, but is the policy of State Farm or other carriers to issue a temporary certificate prior to receiving proof of insurance within the last 6 months?
I would defer to Mr. Sangster
Okay.
for that point.
I'm gonna unzip my mouth and ask a question badly, but
Oh, no.
Mr. Kamenek just told us that page 21, his client's death, he claims that this conversation didn't happen. I mean, does that mean there's a fact question, or is there independent proof somehow that it did happen?
Well, if the conversation did not happen, then for sure there's no misrepresentation. That's the context of the questioning and of the testimony. If there was no conversation.
No, because he's saying you had a duty to tell him if it was going to be canceled. And so if no conversation happened, that doesn't wipe out the claim. That's actually right to the claim.
But you need a misrepresentation or an assumption of the duty to create the duty.
Under 1, but under 4, and I believe that's the other hard factor that Mr. Kamenek's arguing, the agent assumes an additional duty by either express agreement with or promise to the insured.
Right.
If he's saying, we'll look into this, we'll get it. Is that a fact question on that?
No. There was no express undertaking to come back to the plaintiff and say, okay, your policy expired today. There was no such express undertaking, and that's what is required by Hartz. It's a huge jump forward to argue that because 2 weeks earlier, Mr. Heinzman told the plaintiff that if you don't get the evidence in to Farm Bureau of your prior insurance, then they will reject your application.
Again, though, if he says that didn't happen.
But that's the source of the alleged misrepresentation.
No, there's also the additional fact that there was a certificate of insurance issued. Now, there's no conversation particularly that they're citing to related to that, other than it appears, that is inducing his client into thinking that he is insured.
It was a 30-day policy that was issued.
So the certificate expressly says 30 days, right?
Yes.
Yeah, it's a 30-day policy subject to you submitting. And is there any documentation that says, here's what else you have to submit?
Yes. And in particular, it's evidence of prior insurance, because the plaintiff wasn't entirely honest with us about the fact that he drove his prior vehicle for several months uninsured.
And you said you wouldn't have insured him. I mean, that was always a critical issue. That didn't change.
Yes, but a misrepresentation in the context arising from the plaintiff's allegations would have to consist of something to the extent of, Mr. Holman, even if you don't submit the documentation of prior insurance, Farm Bureau will still accept your application and insure you. That would be the misrepresentation that would be actionable and which would create a duty. And we don't have that here.
But he's trying to help the plaintiff get some coverage, right?
He's trying to help the plaintiff to qualify and to do the right things to.
See, that's more than taking an order, isn't it? I mean,
He's
the rule is,
enforcing.
a captive agent is merely a order taker. He's sitting down and to his credit, okay, now misunderstand whatever, but he's acting in that capacity more than a mere order taker by trying to find him more coverage. If you were a mere order taker, say, listen, I don't know if you're getting canceled or not. If you need a new policy, I'm here to take your order. It seems to me he's assuming a duty, either by express agreement or with a promise to the insured to help him out and try to find some more. And why is that not?
With respect to Farm Bureau in particular, he was making sure that the plaintiff was complying with the Farm Bureau requirements.
Hey, you have 1 minute left if you're splitting your time.
Okay, I'll stop here.
Okay.
And if the record will reflect that I am returning Mr. Kamenik's watch.
Might be the best point you made right there.
Very sharp.
Thank you.
Nice tie.
Good afternoon.
Good afternoon.
Ron Sangster for Defendant Farm Bureau General Insurance Company. Judge Kelly, Judge Maldonado, Judge Treblecock. Pleasure to be in front of you again.
Nice to see you.
Farm Bureau is involved in this on the theory of vicarious liability. So in that regard, I'm going to defer much of my argument in the short time I have left and reiterate what Mr. Letterman said on behalf of the agency. I do want to raise an issue though regarding the certificate of insurance that was Judge Treblecock pointed out.
Okay.
The certificate also says, quote, "This certificate is not a guarantee that the policy is in effect or will remain in effect."
Yeah, I'm pulling
Close
it up
quote.
right now.
Okay. And that is the key to this entire case in terms of relying upon the certificate of insurance as, first of all, a guarantee that there's insurance in effect during that 30-day period and continuing after. And that's what this court emphasized in Holman 1. I've been involved in this lawsuit, in this case going back to 2015. And
Career case.
it's a career case, Your Honor. It is definitely a career case. And in Holman 1, the circuit court ruled only on the dates in the certificate of insurance. He knew as of January 29th, no more insurance after that. He's got no documentation after that to carry over the insurance. Beyond that date, accident occurs February 5th, done. Gets to this court, and in Holman 1, the court says, yes, the lower court was right with regard to the certificate, but also the rescission issue that based upon the misrepresentations that were made in the application, Farm Bureau can void coverage. And that's where they focused on that language in the certificate. In terms of how that information got on the application, in September 2014, there was a conversation between Heinzman and Holman about insuring Heinzman's prior vehicle. And during that colloquy, that's when Heinzman asked, what is your current insurance on your old vehicle, your Malibu? That's where the AAA information came from. Fast forward to December 2014, when he's at the dealership, Heinzman pulls up his notes from the September conversation and says, I need proof of prior insurance. Is the information you gave me back in September still accurate? Yes, it is. And that's where he puts that information down. And then Heinzman says, I need that proof. Response is, I'll get it to you. The proof that was provided by Holman was the old AAA policy from 2013. Obviously not the proof of prior insurance during the preceding 6 months. And again, Mr. Holman also acknowledged in his deposition that he had been driving that vehicle during that 6 month, his old vehicle, during the 6 month period of time without insurance, which is in clear violation of Farm Bureau's underwriting rules, which again are authorized under the Essential Insurance Act. So that's where that history comes in. I believe I'm probably out of time right now. I would just indicate that in terms of his duty to inform, Judge McMillan ruled back in 2021 that that cause of action was not viable. That whole issue went up to this court and to the Supreme Court in connection with the first round of lawsuits. That issue, I would submit, has already been decided by the court and as a law of the case going back to 2021. I think I'm out of time.
No, you're okay, but you're welcome to.
I get what? Just a quick question. Sure. This more satisfying along curiosity things is how much money or damage is at stake that this case has been going on for 10 some years?
This was how much money is involved in damages?
Like what's involved here in terms of?
Well, plaintiff would be in a better position to answer that question.
What's alleged?
that a failure to obtain no fault benefits because the vehicle is uninsured, and a failure to, as pointed out, to obtain non-economic damages, pain and suffering on the tort suit. He did recover economic damages because economic damages under no fault on a tort suit are compensable regardless of if the plaintiff is driving his own uninsured motor vehicle. It's just the pain and suffering damages that are precluded under MCL 500.31352C. So, I mean, those are the damages.
Okay, that's exactly what I was at.
Yeah.
I'm looking at the certificate.
Yes.
I mean, I don't know, I have to think about it. It is confusing. It says certificate of insurance for no fault. It says this certificate may be presented as evidence of insurance with your application for license plates at the Secretary of State's. And then in maybe 8-point font, it says, because the other is in like, I want to say 16 and it's bolded. It says this certificate is not a guarantee that the policy is in effect or will remain in effect in the other language that you said.
Yeah, but that issue with all due respect, Your Honor, was decided and resolved in Holman 1.
No, okay, all
Okay.
right. Well, we were just having
That's
this
law
conversation.
of
All
the
right.
case.
Yes, yeah, that
All right, you're right.
the whole basis of a rescission, again, when insurance companies rescind the policy, you know, it occurs after the fact. It occurs, you know, after the lawsuit report, they do the investigation and they find an undisclosed driver in the household, or they find a misrepresentation in the application. It voids the policy ab initio. So yes, the policy, there was evidence of a policy, but it's not concrete evidence that can never be changed or altered under any way, shape, or form, because if it was a concrete policy that could never be changed, there'd be no basis for rescission. And rescissions happen.
No, I'm not saying you
So-
didn't have the ability to, it went actually to the other point about the representation.
Yeah,
So that's all.
yeah, there were-
I wasn't saying you didn't
Yeah,
have the ability, you do. There's misrepresentation.
Yeah, and again, this court has already determined that issue
Mhm.
in Holman 1.
Right, okay, I got it.
Again, and the whole, even as the Supreme Court observed, the whole basis for why we're here is plaintiff's failure to provide proof of prior insurance. That was in the Supreme Court decision that vacated Holman 2. That's the crystal clear holding that plaintiff unfortunately was the author of his own doom by failing to provide that proof of prior insurance, and to basically take measures to, you know, go to other sources of insurance. And as I point out in my brief, there are the non-standard insurers out there. And I know that Judge Kelly is familiar with those non-standard insurers. I used to represent one such insurer.
I remember it well.
I mean, with all due respect, there's a separate market out there for people like Mr. Holmes, who don't insure their vehicles as required by law during that 6-month period of time. That's why that market exists. So, all those policy reasons that the Supreme Court announced in Hart's about taking care of your own financial affairs, those apply with equal force to what we have here. There were no misrepresentations made by the agent. He never said, don't worry about that 30 days. You'll have coverage anyways after January 29th. That never took place. There's no, you know, at some point, Mr. Holman had the obligation, as recognized by the Supreme Court in Hart's, to take care to protect his interests. I mean, it puts the agent in an untenable position that, well, I can sell you this policy, but if you go down the street to that agent, they can get a better deal down there. I mean, it's up to, again, as the court recognized in Hart's, it's up to the applicant to shop around, find the insurance that's best for him, and go that route. So I think that this case is controlled by Hart's. There are no exceptions. I reiterate the arguments raised by Mr. Letterman. The lower court properly granted summary disposition under the circumstances of this case on the very narrow issues that were sent back to the court by the Supreme Court. I'm happy to answer any other questions.
Good.
Any questions about
Nope, you covered it.
insurance agent procedures, anything like that? Okay.
Okay.
Just asking. It's been a pleasure. Thank you.
Thank you very much. Rebuttal?
Let's go to surplus line insurers because yes, they're out there. And this is the
No
point.
names, of course, but
Excuse me?
no names, of course, but we all know who they are.
Of course not.
Yeah.
But quite frankly, you can get coverage, you just have to pay for it. And that's sort of the point here because there was a bid that was obtained by Mr. Heiselman for Mr. Holman at a time that Mr. Holman had not been told that his coverage was not going to be provided by Farm Bureau. That's part of the problem here.
Let
And he
me just make sure.
Sure.
Your client, though, knew, you're not disputing that he knew proof of insurance and the prior valid proof of insurance for the 6 months prior to his application with State Farm was required. Did he
Correct.
not?
That was on the application.
Okay, so he knew that.
Yes.
And at the time he did that, he also admitted in his deposition, he knew he didn't have it. Is that true?
Yes, as far as I recall. Yes.
Okay. And then he also knew that the 30-day certificate was a temporary 30-day certificate, not a promise that he'd get insurance in the, right? I mean, it's stated right on the certificate.
Well, I would tell you that the certificate is equivocal
Okay,
on what it says.
so maybe
It just
not.
is.
Okay,
I'm-
so, and did he understand, he understood that his insurance could be canceled if he couldn't provide the 6 months, right? I mean, that's in the record, I think.
Yeah, yes, but so did the agent, but go ahead.
So your whole argument is that the agent promised to ignore all those things, ignore everything you know, disregard everything you know, but somehow the agent's magically going to make a insurance policy appear and last?
No, the agent removed the opportunity for my client to get other insurance.
How do you remove the
By way-
opportunity? He didn't sign a contract that's the only insurance he's going
But
to get, is it?
all the way through, he gave them the impression that all they had to do is hear from underwriting. It's all over the record. Okay? All we have to do, a matter of fact, at one point in time, my client literally is told, and this is according to his testimony, so I question of fact here. Don't worry that you have not received the written policy. Don't worry about it. Okay? And then later on, after that, I think that was on the 7th of January, and then Heinzman actually gets a notification that, yeah, you're not going to have coverage. All the way through this, my client is waiting to see what underwriting does at Farm Bureau, and he's been told that by the agent, and he's relying on it. 'Cause he testified he was relying
So let
on
me
it.
ask you this, would there be a cause of action then if your client, would the agent have a cause of action against some other agent? If your client went in there and said, hey, I got this quote from Heinzelman down the street. He says, oh, I can beat that. Here, come to me. And he signs up with the guy down the street. Would Heinzelman have, well, you tortiously interfered with my business relationship. I had a promise to give this guy insurance already, which your client says he did. I had a promise that I was going to know this is the guy I'm dealing with. And he walks down the street.
The relationship here is different. We're not talking about at the stage where they're bidding about insurance premiums. We're talking about at the stage where there's the submission of the insurance company's already in effect. And he's waiting and he's waiting and he's waiting. And he's
But
not told.
it's a 30-day waiting period that he knows is going to end, right? Or can end.
No, I'm sorry. That's not, he testified that he expected that at the end of the 30 days, his policy would kick in. Kick in is all over the record here. That was his.
But I think you're missing the underlying point that he knew all along that he was ineligible. So when underwriting finished their job, they were going to decline. Like that seems to be the logical, if you know what the rules are, and you don't meet the requirements, how do you come to the expectation? That's the question.
Yeah.
With all of that, how do you come to the expectation that at the end of the 30 days, when underwriting has done its job, you're going to have insurance?
Because you're working through an agent who is the expert, understands the process. If that was the case, why didn't the agent just tell him right off the bat, you don't have any coverage? You're not going to get it. That's, again,
Well,
they
because
created.
I think
I'm-
he, I
I'm
think,
sorry,
no,
Aaron.
no, no, but I want to make sure that everybody's clear.
Yeah.
Because he was saying that he was insured when he wasn't. Is that not what the record says? That he was telling that their client that he had been insured the previous 6 months and he would provide that proof, but that just wasn't true.
Yeah, he told the agent, send in the AAA agent that I provide you in September. It's still good. That's still accurate. Agent submits it and says, hey, show me the proof for the last 6 months that this AAA was in effect. And your guy doesn't do it. He knows it's not in effect.
But he is still told that they're waiting for underwriting. Is he just being told by the agent that they're waiting for underwriting? Pablum, just for the sake of telling him that? Again, I understand your point, but my point back is that if you know what's required and you go to an insurance agent, they say, let's see what happens. Because that's what happened here. We're waiting for underwriting.
Well,
Here's all the
you're
material.
okay. You're
I'm sorry.
gambling then.
Yeah,
You're-
that's not
you're
a definitive
gambling.
promise.
Because if you know, like,
Well-
for example, if I know that I'm not gonna get, that the rules for me to do X are I have to provide A, and I know perfectly well I don't provide A, but I'm thinking, sometimes they miss this stuff.
Wow.
I could just see if it goes by. I mean, that's kind of what is starting to sound like to me.
Well, but I think that the whole notion that he's acting, it sounds like you're intimating that he's acting deviously a little bit and that he's waiting to see, I know what's going on here. Maybe I can pull one off on these people. I think that would be, according to him, knowledge that a lot of people don't have about how insurance works.
Like the domicile and the residence. I mean,
There we go.
A lot of lawyers don't know that. Yeah, if he didn't have insurance during that period, he's saying, okay, well, that period's expired, right? I mean, that's what a lot of people think. So
Right.
now I'm getting it. So,
And there was some testimony earlier. I'm sorry.
Oh, no, I was just going to say, just moving over back to, I'm hung up with this hard stuff. Maybe it's irrelevant, but remind us, as long as you're giving us lessons today about how some of this stuff works for everybody.
Thank
I'll take it.
A captive agent sells only for that company, right? As opposed to a general agent who says, okay, I got a whole book of, I can write you with Allstate or, whatever, the ones that are non-captive. But
Correct.
But
And
Heisman writes only for Farm Bureau.
yes, he had correct. He had a dedicated agency that was Farm Bureau.
So he
and
was captive, he's a duty taker.
His payment came back to him from Farm Bureau
I
based on a
understand.
percentage of the premiums. Yes.
Okay.
Sorry.
So this,
You said
this
you wanted to hear.
other, this other, company that he got a bid for that was too high, who was that with? Someone other than Farm Bureau?
Yeah, wasn't it?
Yeah. Oh,
It was
yeah.
State
Somebody
Farm,
other-
right?
Okay, so, I mean, under
don't-
4, the agent assumes an additional duty by either express agreement or with a promise to the insured. I mean, he's obviously at that point not an order taker because he's looking outside his captive agency
Right,
for other policies. So,
right. And I think
but
it
maybe that
was-
has nothing to do with the
and-
other issues that are being raised after Holman too.
I agree. And I think I think the record shows that one of the companies was called Provision Insurance, or either that or he checked out with another agency. But yes, to answer your question directly, it was with other insurers. Correct.
I mean,
So
can he even write it to them or is he just presenting it to them?
unclear from the testimony.
Okay.
I think I'm inferring a little bit, bear with me, that what he did is probably describe the situation and to these other insurers or through another agent by way of example, say, can you find an insurer? That's possible. That happens on an everyday basis. And then he probably described the history a little bit and then tried to get a quote.
So does that give rise to a duty?
It's assuming- sure.
If I'm a captive agent and I call my buddy down the street who I know is not a captive agent, and I say, hey, I got a guy here. I don't think we're going to be able to do anything for him. What could you guys do? Here are the circumstances. He comes back, gives him a quote, and then that captive agent gives it to the plaintiff. Does that somehow give him some extra duty to your client?
Well, standing alone, perhaps not, but here, our client, Mr. Holman, testified already that he's waiting to see whether the other policy from Farm Bureau kicks in. And as I explained earlier, I tried to explain earlier, then at that point in time, the agent's going to get other bids. He's doing it voluntarily. He has taken off his cap arguably as the captive agent. Now he's acting as an independent agent. That's how an independent agent would act. And the premise is where I started this, and he took away the opportunity for our client to go ahead and even take that surplus line bid, if that's what it was, at $7,000 a year.
Can you remind me, because the record is wildly long,
I'm
was that
trying to.
resolved in Holman too, as counsel said?
No. No.
I'll have to go back and listen.
No, and matter of fact, on a closing point perhaps, because it's late.
Oh, yeah, I'm supposed to be.
I have both Rons here, so I'll talk about Mr. Letterman because they're both fine attorneys. His first principle, I can't agree with this. He said that where the Supreme Court sent it back was to talk about the cancellation of the binder. That was the language. Maybe it was a misstatement. I don't know, but that's not what happened here. So just so we're clear on this, the Court of Appeals, in its opinion, I think we're at 342 Ms. Schaap had a footnote. It's in the briefs. And they talk about there's a question of fact regarding the efforts Heinzman made to communicate the pending or potential cancellation of plaintiff's policy. I don't think that's what the Court of Appeal, I argued this case. I don't think they were talking about the binder because as you mentioned, there is some language in the binder suggests that it automatically ends on the 29th. I think they're talking about this policy. And then when the Supreme Court came out and talked about it, and again, I usually don't quote, but it says, we take no position on whether defendants owed the plaintiff a duty to warn of a potential cancellation or notify of a recent cancellation in a more timely manner, or the source or scope of that duty. Okay.
But again,
Okay,
going
so-
back to the voluntary assumption, you agreed that Holman 2 at footnote 4, that was dictum, right? Earlier you did.
Yeah, the case was reversed. The Supreme Court didn't vacate because the briefs say they vacated. That's not right. Supreme Court reversed. But I think, and again, as an officer of the court, you've got that statement by the Court of Appeals, and then the Supreme Court, I think, took it and categorized it, if I may, from what I just read and said, okay, this is an issue on remand. I hope that makes some sense.
Yeah, no, that
Yeah,
helps. Thank you.
I read it. I'm not going to tell you something I don't read that way.
Yeah, no, I appreciate it.
So, you know.
Any other questions, Judge?
No.
Any other questions?
I could pontificate here for a couple more hours.
Well, you're out of time. No, I'm
Wait a
just
minute.
kidding.
The wise
my watch?
consumer would, the wise consumer would not go to a captive agent, would they?
Well, it depends what the record is. Because,
At least if something does go south, you have far fewer remedies, I guess.
well, and again, surplus line carriers are in Michigan, as you know, my last comment, 10 seconds. Surplus lines carriers are carriers that write high risk. If you, I know this because of my appellate background, they cannot post an acceptable policy in lieu of an appeal bond because they're not authorized in Michigan. That's how high risk they are. So the Michigan Guarantee Fund won't even cover them. So whatever that's worth in the long run, I'm old, you know something now.
All right. Very interesting
Thanks.
case. Thank you very much.
Thank you, Your Honor.
And we are submitting that case. And that is it for our case call today.